Okay. Lordships, kindly, my lord. Lordships, audio is muted, my lord. May I make a submission? Lordships permits. Lordships, my brother expired, my lord, in an air accident. My colleague is there with the memo for claim of compensation against Air India. Not a single penny is paid to me.
Pardon, what did you say, Mr. Prabhu?
My lord, my brother expired in an air accident, my lord, in Mangalore, Air India. So I am claiming compensation.
Oh, your own brother?
Released.
Okay.
Compensation is not released. So I am praying, my lord, any convenient date, convenient to lordships.
Okay.
My colleague is there with the memo.
We'll see. Which is the number?
My colleague is there with the memo.
Serial number, sir?
It's not the serial number. It is a new matter.
Memo for posting, sir?
Memo for posting. Memo for posting. RFA. Yes.
Memo. Where is the memo, Mr. Prabhu?
Yes, my lord. Memo is there with my colleague, my lord. I'll hand it over in court hall.
I'll require you. Yeah,
I'm sorry. Yes, my lord. I'll just mention the number.
Let the memo be given to the court officer. No?
Yes,
we can't do
that's
it.
all I'm praying. That's all.
I think
It's all right. Yes. Let the memo be given.
Grateful.
Next.
Great.
Which matter? What is the nature of the case? Is it a writ appeal? Which year? Okay. You want it to be listed? Just give it to her, but you have to inform the other side. Okay? Just take it, give it, whatever is convenient, ma'am. So we can entertain the mention. Is it a writ appeal? Okay. File it. When are you filing it? Okay. Just take it, give it next week or next to next week. We'll see it. For restoration. Okay. Which just see the roster.
Careless. Restoration.
You have to inform the other side. Just give a date, ma'am, in that also. After 2, we just see it.
My lords, it's a matter of 2023, my lords. Petitioner has challenged the execution proceedings before the State Commission as well as District Commission, my lords. An interim order was passed by this honorable court staying the execution proceedings. My lords, there was a common order was passed that no proceedings shall continue in the State Commission. However, the District Commission was left out, my lords. I had produced the copy of the interim order passed by this court, but the District Commission is still continuing the proceedings and issued NBW. Therefore, my lords, I filed IA for correction in the matter, my lords. For at least day after tomorrow, my lords.
Just take that also. I've seen there is one matter. Yes. Just switch on your mic.
My lord, before the trial court respondent.
Commercial appeal?
Yes, ma'am.
Just give it to her.
My lord, it's a fresh matter, my lord. Fresh matter, my lord.
Which roster? What is the nature of matter?
Writ petition, my lord.
Writ petition. Just show, just see that.
KLA, my lord.
KLA.
KLA, okay.
Opposite.
It's a petition.
Your Lordship, this writ arises from a miscellaneous appeal before the DRAT. The MA has been disposed of, thereby this writ becomes infructuous.
Which one?
This present writ.
Where is the writ? Is it on board today?
No, sir.
It's not
You are
listed.
filing a memo.
Yes, Your Honor.
Ma'am, just check up. Is it our roster? Huh? Oh, no, but tell us one
Here,
thing.
the GMR, here,
Let's
those
see.
matters are not attended to any courts.
So they can be listed here or 23.
From 2019 and on. From 2019 and onwards.
Or before this court.
It may be listed tomorrow because the court had asked us to produce certified copy. We've already filed it
When is the hearing before DRAT?
uh, on the 7th of August.
We'll have it. We will have it tomorrow, ma'am, this matter. But you should inform the other side.
Sir, adjournments,
My lord, my lord.
sir, adjournments. Page number 5, 27 and 28.
My lord, serial number 28, my lord. My lord, 2 weeks, my lord. I am for the respondent, my lord. I informed the other side also, my lord.
I am for the appellant.
Senior counsel is appearing, my lord, some inconvenience.
You file your submissions also in this.
My lord, it was heard 2-3 times, my lord, before the other bench. My lord, it was heard 2-3 times before the other bench, my lord. My lord, kindly 2 weeks, my lord. We'll argue the matter, my lord.
File your submissions. We will give you a date
Yes, my lord.
at the request of counsel for the,
Respondent.
who is for the.
I am for the appellant.
Which request is not opposed, re-notify on. At the request of counsel for the respondent for an adjournment, which request not opposed, re-notify on.
11-9, sir.
The interim order may kindly be extended, Your Honor.
Interim order if any to continue.
Kindly, my lord, the week after that, my lord.
11, you want
The next
thereafter?
20th or something.
23rd of September.
Yes,
sir.
yes.
You have, are the submissions on record?
Yes, my lord, everything is there, my lord.
23rd of September.
August, September. Yeah, August till.
September.
Let it be September.
Very well.
Board doesn't permit.
Very well. very well.
Page number 6, 29 to 34.
My lord, serial number 34, appearing for the appellants, my lords, pray for a short accommodation. I've informed the other party.
And for the respondent, my lord.
Request for adjournment is sought by the counsel for the
Appellant.
appellant, re-notify on.
Next week, maybe.
We will see it as per our board.
3-9, sir.
Next,
Much.
Page number 35. Sir, page number 7, 35 to 40. Page number 8, 41 to 47.
My lord, serial number 46, I am for the petition, my lord.
which number?
46.
46, sir.
46, yes.
Lala.
6 August.
Pardon?
6th August or 8th August.
No, why not today? We'll reach it, just wait. Okay, you have a difficulty. What is the difficulty? Then we will give a convenient date, not 6th.
Tomorrow will do.
Have you informed the other side?
Yes, sir.
Yes, see.
Date of suspension till.
Oh, yeah. Show me the file. Show me the file.
Similar matter or.
At the request of counsel for the petitioner. You are for petitioner, re-notify on. They'll just give you a date.
17-9.
Next,
Page number 9, 48 and 49. Serial number 1. Serial number 1, Shri Hari Krishna Holla. Office objection for second time.
Second set more. The pass over. This is
Serial number
Petitioner counsel is expired, my lord.
Which one?
Yes, Hari Krishna Yeswala. Serial number 1.
Oh,
He is
is it?
expired. He is expired, man.
Okay. That's. We'll issue notice to you. We have been informed that the counsel for the petitioner, Mr. Hari Krishna S. Holla has expired. If that be so, let a court notice be issued to the petitioner. Returnable on.
23-9.
You appear for the respondents?
No, my lord.
No, government-
You don't.
government.
Let court notice be issued to the parties. Just say parties.
One respondent.
Only one response.
Serial number 2, Shri V.S. Nayak.
I appear for the petitioner, your lordship.
Yes.
I pray for 3 weeks' time for the compliance of the office objections. Deficit court fees is already paid. Remaining 2 are regarding the furnishing the proof of age of the petitioners, your lordship.
Small, different between real lot of litigation. So this goes. This I think we can hear. Here also just. It has to be under the rules. Order passed. You appear for whom, ma'am?
I pay for the workman, your lordship, for the petitioner.
But what is your claim now in the writ petition?
Writ petition is, your lordship, against the CAT order, your lordship.
No, against the labor code, na CGIT.
CGIT, your lordship.
It's a CGIT order.
Yes.
So are you now, they have given you compensation.
Yes, your lordship.
So what are you seeking?
I'm seeking enhancement of the compensation or for the reinstatement, your lordship.
But tell us what is wrong in the order. They have given you compensation.
Lordship, I will grant me 1 day's time, your lordship. I'll make the submission.
Re-notify tomorrow. We'll have it tomorrow, ma'am.
1-8,
Please,
madam.
Please, your lordship.
Serial number 3, Shri Ashwin Haladi.
To pay for the appellant. Pray for a short accommodation.
Pardon?
Pray for a short accommodation, 10 days, my lord. I will file my English translation, my lord.
This is.
That's the connected appeal. The connected appeal, my lords, has been admitted by this honorable court, my lords. Stay has been granted. My lords, I will pray only for a short accommodation to rectify the office objections. My
But this is maybe must they could come out with- From here it goes to he may accelerate. But you will, is the notice issued on this?
No, my lord, notice.
No, no?
No.
We'll issue notice.
In the
You are
meantime-
there. Let's see, we'll consider it. Issue notice. So and so accept notice for one, let notice be issued to the other respondents returnable on.
1410.
Pardon? No, you accept for one, two, anyone appearing for the BBM,
BBMP, my lord.
BBMP.
My lords, in the, lords, in the
BL
writ
Sanjeev
petition,
will appear.
Huh?
BL Sanjeev will appear.
in the writ petition, my
Issue
lords.
notice to the respondents two and three returnable on. Just give it in September, October.
1410.
Lords, kindly, lords, may I request your lordships to reserve liberty to comply with the office objections, my lord.
In the meantime, the counsel for the appellant shall comply with the office objections.
Great.
Do it.
Please,
positive.
please, grateful.
Serial number 4. Shri Abhishek Chandragaud.
For the petitioner, my lord, I request 1 week time to comply office objection, my lord. I have paid court fee, my lord.
You have paid court fee.
Yes, my lord.
You argue on the merits. What is there?
My lord, I challenge the CAT order, my lord.
No, sir. That's Murali.
See, you have the file.
Yes, my lord.
Come to page 25 and 26. Now 26 at the top.
Yes, my lord.
What does it say? Based on this judgment, Murali's judgment is relief granted. Where is Murali's judgment?
Murli judgment is at annexure E, my lord.
Last annexure.
162, my lord. Page number.
What has been granted in Murali's judgment?
It was disbursement.
Dismiss the application, my lord.
Yes.
My basic pay was revised, my lord, when I am in non-executive cadre, ma'am, my lord. When I was promoted to executive cadre, my lord, my basic pay was reduced, my lord. And the reason that pay anomaly will happen between existing senior in executive cadre and promoted petitioner, my lord. On that ground, I have challenged, my lord.
saying that the pay must be protected.
Yes, my lord. When I promoted to executive cadre, my lord, non-executive wages must have to be considered, my lord. Basic pay, my lord. At annexure A5, my lord.
Challenged before this court.
No, my lords.
Sorry, my lord.
Only case has not been challenged.
Challenged, my lord, in none of the writ petition, my lord. We have connected.
What is the writ petition number?
It is
Pending.
fresh matter only, my lord.
Has it been filed?
Yes, my lord. We have filed, my lord. 10 connected matters, my lord.
This issue.
No, my lord. It doesn't came before the court, my lord. Yes, my lord.
We'll do one thing, then you remove the objection.
Yes, my
And
lord.
those appeals also listed.
Okay, my lord.
Okay.
Issue notice to the respondent, my lord. Meaning.
Carry out you have to pay the court fee. Court fee have.
Yes, my lord. I have paid, madam.
Let all the appeals be listed.
Yes,
and we
ma'am.
will issue together.
Okay.
Request of counsel for the petitioner to remove the objections, re-notify after 3 or 4 weeks. Get all those petitions also listed.
Please, my lord.
29,
Much obliged, ma'am.
serial number 5, Shri Pradeep Nayak.
Petition become infructuous, withdraw the petition.
The memo you are filing,
Memo filed, my lord.
the counsel for the petitioner has filed
Innocent.
a memo for withdrawal. A memo which reads as under memo dated 31/7/24, which reads as under. When a counsel for the petitioner reiterates the prayer that the petition be dismissed as withdrawn, it is ordered accordingly. Just see the IS, man. Any IS pending?
No, yes, sir. Serial number 6,
I appear for the petition. I'm instructed that the matter is settled before the trial court. Yeah, it is settled. Your Lordship may kindly grant me 1 week time. I'll file a memo with the instructions.
Take your submission.
Please, my lord. If that is the case, my lord. If that is the case, please.
You are for the respondent.
Please, my lord.
You also agree?
My lord.
Agree with him?
My lord, I agree, but that is only hearsay what we have learned. I am also yet to receive.
Say from him or from any other source?
No, that I have
He
to,
has said.
no, what he has said. I have yet, I mean, only from the union I have to get the instructions, my lord. For that reason,
Do one thing, we'll pass over. Get your instructions.
my lord, instead of that, can it be taken up tomorrow, my lord?
Why should we? We'll do it today. Get your instruction.
2:30, 2:30.
2:30, we'll have it after lunch.
Mm,
Any difficulty for you today?
There's some difficulty. Tomorrow, my lord.
Just call, you are 5 minutes away. Just go and call and then come back. We'll take.
Very well. In fact, my lord, the concerned person is not in station, therefore my difficulty, my lord.
Not in?
Not in India. That is my difficulty, from whom I received in
With this information technology and everything, he may be sleeping there
we said that is the reason. That is the reason.
tomorrow.
Tomorrow, my lord. I'm grateful. Please, I'm grateful.
18, 7. Serial number
weeks may
7,
be
Shri
granted.
Vivek Kumar.
Office objections, my lord. 2 weeks may be granted. For 2 weeks, my lord. Dismissal and suppression, my lord. Cost was imposed by the court.
Yes.
But 2 weeks may be granted, my lord. For office objections are there.
What are the office objections? You are ready to argue? We'll hear you.
But the land has been acquired by the fourth respondent, my lord. But the amount is not dispersed, my lord. Amount is not, compensation is not dispersed to the appellants. There is a big scam in the, and also the complaint is pending before the Lokayukta, madam. Lokayukta, about this scam. 3,322 acres have acquired by for the purpose of the IT park, my lord.
But they record that paid compensation of 31 lakhs.
No, the remaining 60 lakhs is fixed, my lord.
But did you make a claim?
Yes, my lord.
Where?
Before the authorities, my lord. They have not paid the, my lord.
R2. R1 is the check, my lord.
Huh?
R1 is the check, my lord, 113, page number, which was issued in their name.
See, this is what has been paid. Did you challenge this? Did you challenge
Yes,
this?
my lord.
Did you seek enhancement?
Yes, my lord.
Where?
Before the authorities, my lord.
Before the
Fourth,
authority.
fourth respondent.
But then, what was your claim in the writ petition?
Only the meager amount has been, my lord. 1 lakh.
Let's see your prayer in the writ petition.
Page number 35, my lord.
The amount is determined for 62 lakhs, sir. Only they paid, my lord, 40 lakhs.
The acquisition itself.
I challenged the acquisition proceedings, my lord.
You are not seeking enhancement.
Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord.
And where is the determination that it is 62, whatever you are saying, 60 lakhs? Where is the determination?
By the fourth respondent himself is a fixed, my lord.
Where does it say so?
Writ petition is stated, my lord.
See this page 114, you have the copy?
No, I don't have, my lord. Only.
14 says 31. This is a receipt of having the compensation, receiving the compensation.
For 1 acre, my lord. It was specific.
1 acre.
1 acre.
1 acre, my lord.
31 lakhs.
And this has been encashed also?
Yes, my lord.
What remains in this?
Remaining amount is not paid, my lord.
Where do we get that there is a remaining amount? How do we get that? Where is a document to show that there is a remaining amount?
My lord, what happened, my lord? The fourth respondent issued the check and taken back the check also, my lord. In this regard, the complaint is lodged before the Lokayukta, my lord. Not only this appellant, my lord, there are several cases are pending, my lord.
Just see page 113. 113, you don't have?
I don't have.
Check was in her name only. By mentioning account number was also mentioned in the check, my lord.
Right, we don't know it. Let him have his file.
Yes, my lord.
Next week, my lord.
13-8, sir. Serial number 8, Shri Naveed Ahmad. Serial number 8.
Kindly 2 days time may be granted to comply the appeal objection. 2 days time may be granted now to comply the appeal objection. There are 4 objection along with full cost title needs to pay in the.
What remains in this? Why did you file appeal?
On.
Who is the counsel? You are the counsel.
Yes.
So now what remains of this?
Now I'm appearing behalf of Naveed Ahmad. Mr. Naveed Ahmad.
Where is he?
Head up in another quota.
We will pass over. Call it. Okay?
Okay.
Pasor. Serial number 9. Nataraj. 9.
Pass over.
Pasor. Serial number 10. Sri Chandranath Hariga.
Yeah, appellant in this case, my lords. All the documents are in Kannada, my lords. Need 2 weeks time to. For response. In 2 weeks time to comply with the office objections, my lords.
Which order you are challenging?
Let's challenge. Writ petition was filed challenging the order passed by the past rejecting my form number 7, my lords.
When was that? What is the date of the impugned order?
That's the date of the.
Which order you are challenging?
Annexure B to the writ petition, my lords.
Annexure B.
To the writ petition.
There is
There-
a writ petition before us.
No, writ appeal, my lords, I'm challenging the learned single judge's order.
There is the learned single judge's order.
My lords, that we have obtained the certified copy, my lords, we shall.
File it without there. Show us.
That's. Sorry, my lords. ಇಲ್ಲ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೆ ಕಾನ್ಫರೆನ್ಸ್
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಎಕ್ಸಾಮ್ ಇಲ್ಲ.
Taking 2 weeks time, my lords. All the documents are in Kannada, my lords. Form number 7, the order, impugned order.
See, what is the case on merits also? You challenge somewhere, something happened in 77.
That's
Huh?
maybe passed over, my lords.
Pass.
Get
And get 2 copies of this.
Indeed, my lords.
Eleven. Abhishek Mali Patil.
Let's kindly grant me a week's time, my lords, to comply with the office objections, my lords.
Now, what is he, where is he now? Is he still pursuing this course?
My lords, what has happened, my lords, there was an interim order passed by the learned single judge, my lords, to take up the examination. I've already taken up the examination. My lords, as regards, my lords, 80% attendance,
First year.
2020. My lords, for the postgraduate medical course, my lords, it's a 3-year course. Examinations are at the end of 3 years. That's
End of 3 years.
end of 3 years, and it's not first, second, and third, my lords. Final, I finished, my lords. I've already appeared.
Is he attending the classes?
I'm done, my lords. I'm done with the course.
You have completed 3
Yes,
years?
my lords. I've completed 3 years, appeared for the examination.
Also.
Yes, my lords.
And what happened to the result?
Learned single judge, my lords, has dismissed the writ petition. To that effect, my lords, we are.
What happened to the result?
Results are, my lords, withheld by the university. I have passed, my lords, but they are not announced.
That's the only issue now.
Yes, my lords, yes, my lords.
This has been issued. What are the objections?
My lords, I'll comply, my lords, if your lordships may kindly grant me.
To be done. Why are you delaying it? We don't understand.
My apologies, my lords. There's been a default on my end. My apologies, my lords. Kindly grant me a week's time.
2 weeks are granted to remove.
Great.
14-8. Serial number 12, Shri Suresh.
Hearing for the appellants, Your Lordship. Your Lordship prays 2 weeks time, Your Lordship. There are more than 100 pages of translation. More than 100 pages.
List on 9th of September, counsel for the
Achha.
appellants to remove the objections.
Serial number 13, Kempegowda.
The connected matter, my lord, the appointment of the appellant was our notice was ordered yesterday, my lord. This is in regarding to file the 2 writ petitions, my lord, a common order was passed. This writ appeal was in the direct the respondent 1 to 3 to consider our applications, my lord. For from the post of helper to this is the
Similar matter was urgent to 10-9 million yesterday. The Anganwadi
Is that matter which is listed yesterday?
10-9, my lord.
10-9 million.
10-9.
Please. And in this, my lord,
Notice has to be added.
one for the cancellation of my order, my lord, yesterday matter. Today is to consider the application of the fourth respondent. Now, my lord, in this case, the caveat filed, I will permit me to serve the copy to the,
No. This, but both are different.
both are 2 writ petitions, common order. My lord.
No, but here it is, the Anganwadi is C or B?
C, my lord.
C.
See, it is pertain to the same persons, my lord. Yesterday matter, today 6:30 is I am the 4th respondent in the writ petition.
We'll have it on that list on 10th of September.
Then, my lord, they permit me to serve the copy to the caveat.
The objections shall be removed before the next date of hearing.
Please, my lord, see the 4th respondent filed the civil contempt. Today is listed before coordinate with portal 1.
You will make your submissions there. But how are you concerned? They are concerned.
The contempt is their concern, my lord. I am not the party. Here is I am the aggrieved, my lord, regarding the.
Remove the objections.
Please.
Remove the objections.
Please.
Serial number 14. Saga.
Appearing for the petitioner, my lords.
But the objection, the office objection, my lord, is in relation to the statement of objections filed by me. I'll rectify the defect, my lord. Kindly grant me a next. I'll rectify the defect. Kindly grant me it.
Which where is the objection is about?
But in the objections filed by me, that is respond number 2, there are some office objections.
What is your stand in the objections?
But the main contention of the learned petition, counsel for the petitioner is that he has not been notified of the proceedings before the Honorable Uplokaayuktha. That is incorrect. He was notified, he has filed his objections, and the objections have been considered before coming up with the 12-3 report.
You have got the copy of the objections?
No, my lords.
His objections?
No, my lords. Objection. Copy of your objection. No.
Give him a copy.
I will give it.
When is the connected matter listed? Because I think this one thing to the postcode.
Yes, but discipline the Panchayat Raj Act ಅಲ್ಲಿ notice issue ಮಾಡಿದೆ.
Serial number 3, today's history.
There were certain matters yesterday. What is the date? You have any idea?
But in our Lokaayuktha matters, before my lords.
29/8, sir.
29. We'll have it on 29/8. Just give him a copy of the.
I will.
We want all the judgments on this 12-3, 12-4.
Very well.
Just give a compilation of that.
Very well. We'll do it.
He'll and a counsel for respondent number, which respondent?
2. Second
Who
respondent.
states that he shall serve the copy of the objections on the counsel, for the petitioner during the course of the day. It's a list on 29/8.
Very well. And also, my lord, kindly permit me to comply the office objection. And I will have to.
Additionally, the counsel for the respondent number 2 shall comply with the office objections
Within a week.
within 1 week. The counsel for the parties shall file the compilation of judgments in support of their stand.
Grateful.
Grateful, my lords.
Serial number 15, Sri Radhakrishna Holla.
My lord, in this matter, I appear for the respondents, my lord. I pray for a week's time in this matter. My lord, I filed my memo of appearance recently. What has happened, the objections have been filed by the respondents. Usually in writ petitions arising out of CAT, objections are not filed. I did not know. I don't have the copy of the objection. And the second set is also have to be filed, my lord. Within a week, I will file the objection and
Now tell us one thing. You are for the petitioner?
Yes, my lord.
Now, what is wrong in this judgment?
Stepping up of payment. Pass for the matter.
I will pass it over. You must see there is judgment of the Supreme Court exactly covering. They say so that in case of ACP, MACP, there is no stepping up, even if the senior is drawing lower pay. So that's the issue.
Yes, madam.
That's the issue.
Yes.
It gets covered against you by the Supreme Court judgment. So just look into it. We'll pass over.
Yes.
my lord, kindly have it at 2:30, my lord.
Yes,
I will
yes,
see.
we'll have it after lunch.
Please.
16, Shri Satish.
Comes for petitioner, my lords. It's matter pertaining to transfer. During the pendency, my lords, the respondent number 3 has retired from service.
So nothing survives.
Nothing survives. my lords.
So you want to withdraw it?
Please, it may be rendered as infructuous. my lords.
The learned counsel for the appellant, petitioner fairly states that the petitioner having retired, the present petition has become infructuous. Noting the said submission, the petition is dismissed as having become infructuous.
Great.
Good.
So, Seventeen. Shivram.
Yes, I appeared for applying to your lordship. But next week, your lordship, in the meantime, I will ascertain, my lord, I was told that there's a suit is filed. Whether it is a fact or not, I will ascertain, my lord.
What do you want to ascertain?
Whether the suit is filed, my lord, or not, that's what I was told by my learned friend just now. I will just find out and because I didn't have the file also, my lord, it was.
You were the petitioner before the learned single judge.
That's correct, your lordship.
But so the only thing is, you must be knowing now what happened. before
The parties, my lord, are not in touch with me, my lord, and after filing the case, your lordship, this was filed, my lord, in 2023, my lord, January. Now we are in 2024.
The direction was to that temporary injunction.
Yes, your lordship. I was told that the suit is there. If there is suit is filed, your lordship. If some order is obtained, I will say before the court that I may be.
You must be knowing that.
No, not having.
For the respondents.
Yes, my statement.
I appear for the respondent.
For the state.
No.
Private.
Private respondent.
Private
Must be knowing it. Are you a party there in the?
This I am a party.
He has told me that a suit has been filed. I don't know whether the injunction has been obtained or not. Whether I should do anything in the.
The judge also.
My lord.
That has been noted.
Yes, sir.
See para 3.
Yes, that I have seen you.
Do one thing, we'll just pass over, get your instructions.
Or else your lordship may say, my lord, in view of the filing of the suit, the writ appeal may become infructuous, your lordship may say.
No, then we will only note what the.
I don't have his telephone number also, my lord. That's the.
Pardon?
I don't have his telephone number also, my lord. That's the reason, my lord. Otherwise, I would not have sought for time. Immediately, I would have taken phone, my lord, and contacted and or else I have to address letter to him, my lord, and I have to get an information.
You'll have it then tomorrow or day after, whatever you want.
Yes, if my learned friend able to get their number through, he's from Tumkur, I will request my learned friend to get their number and talk to him.
Get the information from your clients on this.
Tomorrow you ask me.
Tomorrow, my lord may have this.
Please, tomorrow.
I also don't want to keep the matter pending, your lord.
Right, you're right.
Yes. Only thing we must ascertain what exactly the situation is, that's all. Yes, sir.
Tomorrow.
18, sir.
Oblige me.
Serial number 18.
May appear for respondent workman, this matter.
Yeah, for the package.
Lordship may kindly get short accommodation.
Why?
Lord, this is the matter where Milord's writ petition before learned single judge came to be allowed with back wages, Milord's. Milord's, we will address arguments, Milord's. Finally, a week's accommodation, Milord's, not I will not seek further adjournment.
But the issue arises like this, my lord. He was an employee and he had chronic back pain. And after my lord medical examination, everything, my lord, we gave him a notice and he admitted that he is not in a position to undertake that work. Therefore, my lord, on medical grounds, he was discharged. That was questioned before the Labour Court. Labour Court, after inquiry, my lord, came to the conclusion that it is proved that his medical condition did not enable him to work. And evidence was also adduced, giving reasons, and all the evidence was taken note of. The Labour Court, my lord, rejected his application And against that, my lord, the workman filed a writ petition. The learned single judge, my lord, entertained the writ petition and reappraised the evidence on record and said that probably he has got this back pain because of the nature of the work he was doing. Therefore, set aside the termination and restored his position and directed back wages to be paid.
Because of this condition, was it affecting his working?
It was, my lord. That is the medical evidence. My lord, in the pendency of this,
About medical evidence would be the back pain. But the working, was he taking a habitual or was he taking leaves?
yes, my lord.
frequently?
He made several representations to the management to say, I cannot do this work, give me some other work. And he was habitually absent, but notice was given.
Got an opinion from the medical.
Yes, my lord. At that stage, medical opinion is also taken.
This procedure is otherwise contemplated.
Yes, my lord. In the standing orders, there's a provision, my lord, that for medical reason you can terminate him.
What would be the terminal benefits you would give on such,
yes.
decategorizing on medical grounds?
Yes, he will be entitled. He was sent a check, my lord, for the amount due to him. He then returned the check to say, I don't accept this. But my lord, during the pendency of the writ appeal, he repeatedly made a submission to say, I am now feeling better. I am willing to work. So, my lord, we consented, and the Honorable Court appointed my lord Sanjay Gandhi Institute of Medical Sciences to re-examine him. So that examination is carried out, a report was submitted, and based on that report, my lord, he has reported back for duty. So he is now back to duty.
So he is working now.
Today he is back to duty.
Then what
The only question that remains now, my lord, is for the period when we discharged him from service, till the time the learned single judge directed his restoration and back wages, is he entitled to wages?
during the period of absence?
Please.
And also continuity of service, minutes. We will argue, minutes.
How much is the period?
It's about 2.5 years.
Well, and have you
Yes.
worked out what are the back wages need to be paid?
My lord, he has worked out the back wages, and according to me, it comes to some 65 lakhs or so.
We filed a memo, my lords. It comes to around 85 lakhs, minutes. Anyway, my lord, subject to correction, we will argue.
The termination, my lord, was in 2014. And his reinstitution during the pendency of the appeal was in 2023. So
What is the monthly emoluments you get?
today it's about 82,000.
82,000.
So what is the basis to come to that 82 lakhs?
We will argue, minutes. Sorry, inconvenience. Your Lordship, would it be permanent? Lordship may have.
What according to you is the undisputed amount?
Lord, we have, according to us, nothing is due because our action.
Trying to justify the action.
Yes, my lord.
The action being justified.
Yeah.
Is not entitled.
And that's the submission. The only short point that will arise for kind consideration is this, my lord. On evidence, when the labor court examines it and he practically admitted in the proceedings that he has this problem, he cannot work. The learned judge, my lord, interferes with that, saying that the labor court did not examine a particular document. That is factually incorrect because in the award, the document is referred to. It's a Kannada document, fully read, understood. There's a comment of the labor court also to say that this indicates that he had this chronic problem. So whether the learned single judge could have practically sat in appeal over the order of the labor court was the question, that limited question that will arise.
The request of counsel for the respondent, re-notify. Just give it.
Your Lordship may have it, would it be possible to have it Tuesday, minutes?
We'll give you a date as per.
Please.
Just give it.
14/8.
My lord, there are,
Any evidence documents required to be placed on record?
we have placed everything. Everything is on record. My lord, there are two office notes, my lord, they may not survive. One is IA3 for direction, my lord. That IA3 for disposed of, IA3 was to subject him to medical exam. He was examined and a report came. And the office note is regarding non-filing of copy. That also has been received now. So these two office notes may not arise.
Senior counsel appeals for the appellant submits that IA1/2023 does not survive for consideration.
3 of 23.
3 of 23.
serial number 18. Second note.
Accordingly, the IFP of 23 is closed. We move to next.
The office note also not is satisfied. They've served as a copy.
So you also submits that the other objections as notified by the registries have been cleared. Noting the said submission, re-notified.
Please.
So and so at the request of counsel for the respondent. Says. Next.
Serial number 19, Shri Mahesh Uppin. Mahesh Uppin.
Time not to comply.
Yes.
Time not comply.
So
Compliance. Not.
Otherwise, I'm ready to argue the matter on merits, not tomorrow. Not Saturday. Lapsing of acquisition right on account of non-deposit of the compensation by the
Please argue, otherwise I'll dismiss it. You please argue whenever you can. My lord. Tomorrow, my lord. Sorry, Mr.
Lord, I have to file legible copies of some of the annexures.
no, but it has been dismissed now on 13/10/23.
Conditional order.
13/10/23. Because of the order of 13/10/23, that stands dismissed. So you have to file an application for recall. At the request of counsel for the applicant. You have to see whatever you
Clear.
have to take steps.
Clear.
Four, nine. Serial number 20, Shri Anandaram.
23, I appear for petitioner, my lord.
On the last day,
20, sir, 20, serial number 20.
So yes, for 1 to 12.
Notice is awaited.
That's right, you want to know.
Matter relating to a grant of ACP, my lord. The tribunal, my lord, has passed a cryptic order without considering.
Different matter, this is item 20.
Sir, serial number 20, sir.
The two official memorandum on which I had placed reliance, my lord.
Sir,
And I
serial
have
number,
enclosed the judgment of Madras
Lord,
This is item 20.
Sorry, my lord, I'm sorry, I'm very sorry.
Lord, before the learned single judge, my lord, the advocates Sanat Kumar Shetty and Keshav Bhatt had
You
to
appear for whom?
state.
For one.
Yes, my lord.
Yes,
So 2 to 12 have not been served. It's still awaited.
awaited. My lord.
So did you avail civil court remedy?
Yes, my lord, there is already a decree for partition. And Lord, there was a civil suit for partition.
After this order of the learned single judge?
No, my lords, prior to my lords, and my lord, Nagu Shetty, my lord, is my predecessor. On behalf of Nagu Shetty, my lord, the partition was decreed. And my lord, as the suit was pending, my lord, as on 1374, when the Land Reforms Act came into force, the receiver, my lord, filed form number 7 on behalf of the family. Now, my lord, there is a rival claimant, my lord, one by name Channu Shetty, who are, my lord, the respondents before your lordships. Now, one of the family members of Nagu Shetty by way of Sidhu Shetty, he, my lord, enters into a compromise with the rival claimant and settles the claim. On the basis of compromise, Land Tribunal passes the order, my lord, granting a portion in favor of one of the family members and, my lord, also in favor of a rival claimant. Now, my lord, rival claim had to be decided by the tribunal, my lords, whether there is a compromise or not. The rival tenancy had to be decided by the tribunal.
No, but what is the effect of this order at page 27?
Lord, page 27, my lords, the learned single judge comes to the conclusion that I have to go to the trial court on the reasoning that, my lord, I have not produced list number 3 of the earlier partition deed. Now, list number 3 is the very same, my lord, partition decree under which, my lord, the other respondents are also claiming. That is that Sidhu Shetty is also claiming. Because there are 8 children of Nagu Shetty, my lord. One of them is Sidhu Shetty, the other is Kusu Shetty.
Will the filing of civil suit will not help you when
It will not, rights are already declared, my lords. The rights are already declared.
But where is the challenge to those rights?
Pardon me, my lord.
Rights declared in which proceedings?
In the trial court proceedings, my lords.
The trial court proceedings is before the land tribunal.
Not before the civil court, my lord, in OS number 188 of 1967.
Then how a writ petition was maintainable then?
No, writ petition was maintainable for this reason, my lords. My lord, the Nagu Shetty, my lord, was a tenant in respect of the scheduled land. There was a rival tenant by name Channu Shetty. Now, my lord, Nagu Shetty had 8 children. One of them was Sidhu Shetty. So, my lord, the land tribunal grants the order upon an application filed by the receiver in favor of Sidhu Shetty, only one son of Nagu Shetty. There was also a rival tenant by name Channu Shetty. Now, my lord, in respect of the tenancy of Nagu Shetty,
compromise was entered before the tribunal.
Yes, my lord. Yes. Not before the trial court. Trial court, all the children of Nagu Shetty got the right.
But not a party there.
In the tribunal, no, no.
Now you have challenged that compromise.
That order of the land tribunal I have challenged before the learned single judge.
That was negated.
That was negated.
The notice to respondents 2 to 12 is incomplete.
Yeah.
Because notice be issued to respondents 2 to 12. Returnable on.
Not in addition, I may also be permitted to serve on the advocates who appeared in the writ petition.
Better would be serve on the
Yes.
client. The advocate may not have
Yes.
instructions.
Yes, my lord. Yes.
1410,
Oblige.
1410, 21, government advocate.
In this week's time to complement office objections.
What are the objections you have to clear?
Well, the number is not tally with the annexure came in. Description and date has to be mentioned.
Clear it within 2 weeks.
Yes, we'll clear it. Thank you.
Just carry out the objections.
Yes,
2
ma'am.
weeks to remove the objections.
Yes, ma'am.
Re-notify.
14.8, sir. Twenty-two, seal number 22.
What you will recollect this matter, I'll not trouble lordship with the two judgments per se, but the point is there has to be patent lack of jurisdiction. That's the test. And the issue that the fact that it is a jurisdictional issue is clear because it's a section 16 matter. So it's touching upon jurisdiction. How is it patently lacking is a question of fact, and may I just take 2 minutes to explain what my submission on that is.
So that why in 226?
That's right, Lordship. 226. Lordship, this.
226 public law remedy. What is public law issue here? It's purely a private contract, except the fact what you are trying to bring in is
Lordship.
The arbitrator, the tribunal
Lordship.
constituted under section 11 by this court. And hence he has the trappings of a public authority.
That's right.
And possibly see.
No, that lordship, there is, in fact, that there is a clear line of judgments that say that an arbitral tribunal being a tribunal is amenable to 227. I've said 226. That's right. But lordship, even the judgments, SBP, including SBP, the fact that an exception is carved out for a writ court to interfere means that a writ court can interfere. Therefore, on the question as to why a writ court, SBP itself answers that in an exceptional situation, in a private arbitration, writ court can interfere.
Let's assume there are no judgments. What is the remedy against 16?
That's right. Now, may I come to that?
Remedy against 16.
May I come to that?
It's not an appealable order.
It is not. It's not.
Under the appeal provision or under 37 also?
I need to wait till 34.
34.
I need to wait till 34. But the exception carved out, as much as the rule is that this court will not interfere.
34 would be only after the award.
That's right. That's right. So this is not 34. I'm not saying this is 34 or 37. This is clearly 226 or 226. In fact, I've only said 226, should have said 27 also. But lordship, the point is this. May I just submit on the fact as to why perversity? And then I'll leave it to lordship's discretion, because of course it's a discretionary matter. In any case, it is a discretionary matter. The exercise of jurisdiction under section 11 is on a different contract, whereas today the order passed, assuming jurisdiction to himself, is on a contract which is consciously made different by the parties. Therefore, lordship, it's not a question of merely Delhi and Bangalore not being the same. That's only an issue of seat. But the arbitration contemplated itself was different. Because under agreement A, in fact, can I trouble lordship? Yes.
See the other agreement.
Can I trouble lordship with the first
seat of arbitration?
Yes. In fact, the first contract lordship will see at annexure B, where at page 28 at page 65 is the first arbitration clause, which is the arbitration going on.
Which is this arbitration?
Which is this arbitration. That is at page 65, lordship will see the arbitration clause.
28 is the first agreement.
28 is the first agreement. 28
proceedings, seat being in Bangalore.
Being in Bangalore. That is 28 at 64. Clause 19 is the dispute resolution. Clause 19 at 64, if lordship goes to 65, 19.3, it is a Bangalore-based arbitration before a sole arbitrator. Lordship sees that. Now, lordship, on the same date as this.
Just only to be clear.
Yes.
This is what was invoked in section 11.
That's right. This alone was invoked in section 11. Now, lordship, I am one of the parties to this agreement. Thanks to this agreement, I have entered into a supplementary agreement with another party, not the same party.
No, but were you a signatory insofar as this 2865 is concerned?
I was. So I am the common signatory between this agreement and the other agreement.
So we take it you were a party also in section 11.
I was a party in section 11. I have absolutely no problem with the arbitration which is going on presently under this agreement. Now in this, thanks to this agreement, to give effect to this is a development agreement. To give effect to this development agreement, I appoint a contractor, which is my next agreement, which lordship will see at annexure C, 69. At page 76, lordship will see under that service agreement what my arbitration clause is.
Which page?
At page 76, lordship.
36.
76, clause 14.3.
Yes.
And that's a arbitration before a sole arbitrator with the seat being in Delhi. Now, therefore, what the parties, by exercising the party autonomy, has done is that on the same date after one contract is entered into, to give effect to some part of that contract, they enter into another agreement. And in that agreement, they consciously say it will not be the same arbitration agreement. It will be a different arbitration agreement. Therefore, party autonomy demanded that both parties together acted and consciously carved out a separate arbitration for that. When arbitration starts in under the first agreement, I am a respondent. He is also a respondent.
Who he means?
The party to the second agreement. That's a contractor.
Now, what is the name of the contract?
The CAV infra. Infra.
CAV infra was not there on the. first
He was only a consenting party to the first. He was not a contracting party. May I show Lordship the parties? Kindly come to page 28, Lordship. Page 28, Lordship will see developer group, which is me.
Yes.
MSK Shelters, which is the
But
claimant.
this CAV was also in section 11.
That's right. So CAV was not in section, Lordship, that section 11 order is that page 92, in which CAV was a party because it was a consenting party to the first. May I only say this, Lordship? Having participated in the first contract as a consenting party, he and I agreed to consciously carve out a separate arbitration insofar as the second agreement on the same date is concerned. And second agreement starts by saying, the recital says that you have entered into the principal agreement with somebody else. To give effect to it, this contract is being entered into. So therefore, consciously and deliberately, parties have chosen that it has to be a separate arbitration. Thereafter, when the arbitration kickstarts under the first agreement, unilaterally, not bilaterally, unilaterally, he says another respondent in the matter files a counterclaim against me. So it's a strange situation where respondent 2 files a counterclaim against respondent 1. That by itself is unheard of. But I'm not primarily on that because of jurisdictional question. I raise an objection that firstly, it's a different contract. And that needs to be appreciated that by conscious party autonomy exercise, parties.
Why was that contractor a party in the section 11?
That contractor was a party for 2 reasons. One is that contractor was the intended.
And mind it, the terms of reference to the arbitrator does not make any distinction.
No, terms of reference. Lordship will see this order, section 11 order. Section 11 order is not thanks to the second contract. Section 11 order is purely thanks to the first contract.
So we are not concerned with that.
Lordship.
Let's be very clear.
Lordship.
It's your case, the first agreement, he is the consenting party.
He's a consenting party, no doubt.
Section 11 also includes as a respondent.
He does.
There is a reference made inter se the parties to the learned arbitrator.
There is a
reference made inter
yes.
se the parties.
Yes.
Before to the learned arbitrator without any conditions attached to it.
No, there is no consent. Lordship, I'm sorry. Perhaps I'm not able to get
like this.
Lordship.
When section 11 is
Lordship.
Fine.
Lordship.
Even the parties there in the second agreement were the parties in section 11.
Incidentally, yes.
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 Now, when the reference is made.
Lordship.
See the reference order.
Lordship will kindly see the
conditions attached to it that this may govern only the first agreement or the second agreement.
Can I show Lordship the first paragraph?
Yes.
It refers only to the first agreement.
It's all right.
And
just see, let's see.
Yes. At page 94, Mr. So-and-so, learned counsel for the petitioner, and Mr. So-and-so, senior counsel for the respondent number 1 are heard. It is pointed out that no dispute that the parties have entered into definitive development management agreement, agreeing to settle all the disputes through an arbitration. Now, that's the sole.
Also, there is no reference to the Bangalore being the seat of arbitration. But since the petition was here.
Filed here.
They were referred to the Bangalore
That's right.
arbitration.
That's right. It could not have been in Delhi.
But no conditions attached to it, whether we don't know.
Right.
Even the contractor was a party in section 11.
That's right, Lordship. It was a party.
Was all the parties who were there in the section 11.
Lordship.
Right?
Lordship.
If that being the position.
Lordship.
Whether a section 16 could have been maintained.
Lordship, section. Yes.
Or.
Yes.
It should have been clarified when section 11 was being decided.
Lordship.
That this only pertains to this particular agreement.
That Lordship will see in para 1 that it is solely on account of the first agreement. Para 1 at page 94 refers to the definitive development and management agreement and no other agreement. So,
let's assume this way. So whatever the rights and liabilities insofar as the first agreement, possibly your case is, it's only to that extent the arbitration.
That's all my cases. Now, Lordship will see the counterclaim. It is purely under the second agreement that the counterclaim is.
Still argue.
Lordship.
See, your rights are, your contentions are not foreclosed. You will still argue that the reference is based on 22/4 and the date of the second agreement is also same or a different date?
It's on the same date. And yes.
That's the point. Very well, be that as it may. It
Lordship.
says definite development management agreement.
Lordship.
Even the nomenclature is same in both.
Same. No. First agreement is definitive development management agreement. Second is a service agreement.
So you can still argue.
Lordship.
Although the parties were there, they have
Lordship.
been referred.
Lordship.
Whatever it's worth, we are there before the arbitrator. The dispute is primarily related to the first agreement.
Only related to the first agreement.
You can still argue.
Lordship.
And the claims insofar as your case possibly, the claims being against you also
Lordship.
is primarily because of the second agreement.
Again, only insofar as the first agreement is concerned.
So the claim must be limited to first agreement.
That's what I argued.
But you have argued 16, you say you are on a jurisdiction, you have.
Yes,
argued.
Lordship, the reason is this. The reason why it is an abdication of jurisdiction is because there was no, point number one, there was no invocation of second agreement.
That we will not argue. See, in this fact, section 11, we see this need to have been clarified there. When section 11.
There was no scope, Lordship, because it was only purely, it was a section 11 that I filed. It was section 11 that was filed against me. And the scope of section 1, it was so clear, was limited to that. And I have no problem if the contractor has a claim under the first agreement, which is brought within this arbitration. In fact, he has one claim. But a respondent counter-suing a respondent by way of invoking the second agreement, which has not been invoked, point number one. Point number two, that second agreement had consciously carved out a different arbitration. And that's not merely the seat. A different arbitration was carved out.
Right.
Lordship.
That's the right. That's why we are saying.
Lordship.
You should have said 11. There is no question of the contractor coming in section 11.
No, because he was a consenting party, he was made up a party. That's all.
Then you are arguing both. If as a consenting party he's coming. See, we don't know. Let's assume.
Lordship.
Let's assume as a consenting party, the contractor also comes in the first dispute.
He does. And I have no problem with that. I am not saying he should be deleted as a party from the.
There is a claim against you.
That's all.
That's the
my claim is not in the nature of order 1 rule 10 deletion.
I don't. Then you will work it out.
Lordship, may I say this? May I have the satisfaction of at least placing my arguments? I leave it to Lordship. My argument is this. Point number one, there has not been an invocation of the second agreement.
Under 21.
Under 21. And today it is very clear that non-invocation is a fundamental error.
Can you take this plea before arbitrator?
I have taken.
Before arbitrator?
In section 16, I have taken. And this is all relatable to his jurisdiction. Point number two. Lordship, the second point, which is very important, is that parties on the same date having entered into 2 agreements, having consciously sidestepped the first and carved out a second agreement, one party unilaterally cannot sabotage it and say everything has to be merged into the same arbitration. That's my second argument. My third argument, Lordship, is that that there is no opportunity that, insofar as I am concerned, I ought to have had a second opportunity to participate in the appointment proceedings. In that, that's a valuable statutory right, which has not been exercised. He has not exercised, I have also not exercised. Insofar as the Delhi arbitration is concerned.
Pause for a moment on this submission.
Lordship.
Can you argue this point before the arbitrator?
I did. The Lordship will see the reasoning of the arbitrator. In fact, none of these points are answered. The reasoning is chloro.
Chloro.
In fact, the reasoning is chloro. Now, chloro works on a principle when there are group companies and when the contracts are connected. Here, one may say contracts have a connection. I am not coming in the way of that.
Group of companies will not come here.
It will not come. And the arbitrator has gone by chloro. The arbitrator says everything together can be merged into one arbitration without recognizing that chloro essentially was nobody's case before him. Chloro is not even argued. He picks up chloro to say.
It is different. It's not part of the.
It is not. It is not. It is not. It's not a group company principle at all. Point number one. Point number two, Lordship, chloro works when there is a principal agreement with an arbitration, when there are subsidiary agreements with no arbitration. Therefore, instead, by applying Sukanya, instead of going to civil court and arbitration, it's all merged into arbitration.
Kings also, Supreme Court.
Cox and Kings also is clarified. Therefore, Lordship, chloro could not have been a reason for this. At least arbitrators should have returned findings on my
but you have
arguments.
To still cross this 226 hurdle.
Lordship, 226, even in fact, SBP is very clear. By saying that writ court will interfere only in exceptional cases, the side of it is, if there is an exceptional case, writ court will interfere. Therefore, 226 or 227.
You have taken that Delhi High Court judgment.
I've seen the latest judgment by Justice Pratibha Singh, but that only says exceptional circumstance and does not qualify. Of course, nobody can qualify what is exceptional. It is, so it is a factual argument. Legally, it is exceptional, but I have to satisfy to pass it through the needle of the facts. Now, my point is this is by applying chloro and not even addressing my points, at least it deserves a notice to be issued and heard in detail on the question.
So you have to still convince us on 226.
Then, Lordship, there is a direct judgment of the Honorable Supreme. In fact, I am not.
Now see page 95.
Lordship.
This should have been worked out there before the arbitrator, or before the court. Second para, appointed the sole arbitrator to enter reference of the dispute between the petitioner and the respondents conducted.
Lordship, the only reason is this context wasn't there at that point. This context wasn't there. The counterclaim was filed much ahead in the arbitration, much later.
Until you plead it, where will the context be there?
That's right. So
the pleaded, look here, this is reference is only for in this agreement. You will not bring in the second agreement.
Lordship, that should have been, in fact, if I would say if my contractor wanted to, he should have pleaded that it should have been. Then I could have addressed it. Nobody addressed it.
Well taken. You can still argue this we are putting it because the fact remains the contractor was a party before the
That's right. That's right.
11.
That's right.
So 11 was made party because it was a confirming party.
That's right.
But the dispute is primarily with regard to 1, not with regard to 2.
Not at all with regard to 2 and only with regard to 1.
You will still argue.
Lordship.
You are not getting foreclosed. See, one thing is there, the reference having been made,
Lordship.
he has the jurisdiction where all parties are before him.
Parties have no difficulty.
One.
Yes.
Insofar as the claim of which is a claim against you is concerned,
Lordship.
you can still argue, is anyone foreclosing the right that any claim which arises from the second agreement cannot be part of this reference?
Yes, because that maintainability threshold has been crossed already.
It necessarily has to be under section 16 or even on a claim and you will file your statement of defense, you can still plead it.
Lordship, may I now express one difficulty? if today, for instance, I want to legitimately invoke that arbitration and file it in Delhi, I cannot.
Why?
Because multiplicity of proceedings will be there. One is already this arbitrator has assumed jurisdiction.
Then no, if you are reading yourself in the, see, then means you are reading itself in this arbitration.
Lordship.
What is your stand?
My stand is this arbitration cannot take within itself the Delhi arbitration.
The Delhi arbitration.
Yes.
Very well. You'll take your chance before the Delhi court, saying that I have come under section 11, please appoint an arbitrator, because this is the agreement. We will see what the Delhi court says. But today, see, that's the point. What we are saying is 16 is actually the arbitrator cannot enter the reference, something like that. 16.
Lordship.
You say he can't go into this, can't look into it, something like that.
Yes, yes.
Inherent lack of jurisdiction.
Inherent lack of jurisdiction.
Possible. But the parties being there, being a confirming party, no objection in section 11.
Lordship.
And the parties were referred to.
Lordship.
And there is a second agreement which you may have a grievance or against which you may have a claim.
Lordship.
Seek. You will say that agreement, that invocation was only with regard to the first agreement. Nothing to concern with this. The difficulty is your 16 has been rejected.
That's right, Lordship.
On that ground.
That's right, Lordship. That's the difficulty.
That possibly may
That possibility is there. So if I today invoke a section 11 in Delhi, this stares on my face. I can't have two arbitrations. And flip side is I can't even raise my counterclaim here because then I'll be submitting to a jurisdiction that I don't want to. Therefore, Lordship, I am genuine difficulty, at least to examine this point of law and lay down the law.
Show us the judgments on 226.
227, Lordship. In fact, by oversight, 227 is missed out. 227 is very clear. There are judgments to say tribunal being
which was the tribunal under 227?
Arbitral tribunal. Yes, that Lordship, in fact, in 1 hour, I'll get the judgment. There's a clear judgment of Supreme Court that says that arbitral tribunal being a tribunal, supervisory jurisdiction will apply. That there is no doubt. And SPB also indirectly says that. By saying writ court can interfere.
You show us the judgment. You will read
it
in the manner you want us to read it, then we will read it in the manner we want to read it.
I will bring that. Lordship, I'm so sorry, I'm not carrying. 1 hour, I'll get that. Kindly pass over.
Yes, pass.
Great.
23.
Appearing for the respondent, my lord.
Appear for the petitioner, ma'am. The matter relating to the fixation of pay. The petitioner had earlier approached the tribunal, my lord, seeking for fixation of pay. That is on completion of 24 years of service. The tribunal, my lord, by its cryptic order has dismissed the application in 2 lines, my lord. Your lordship, I kindly see the order of the tribunal. Page number 16, my lord. Up to para 5, my lord, para 6. Para 5, the only extraction of certain tabulation. Then we have gone through the pleading. 6, admittedly, applicant joined service in 1982. The ACP having come into force on 9899, the applicant got first ACP in appropriate pay scale in 9899. He now claims certain additional ACP benefits to GP, PB and GP. Unfortunately, for neither PB or GP existed in 89. Suddenly, my lord, 89, date is type. They were introduced in 6th Central Pay Commission with effect from 1/1/2000. This claim is therefore rejected. My lord, this is how. On the other hand, my lord, my petition is elaborate. I have relied on 2 official memorandum regarding fixation of pay, my lord. One is at annexure A11, 9899. 2 official memorandum which contemplate that while granting ACP, my lord, the earlier as to how it should be done, it has been clearly stated, my lord. Your lordship, kindly see page number 94. That is the official memorandum dated 9/9/2010. Without considering these, my lord, the tribunal dismissed the application. My lord, in fact, I had filed a rejoinder to the objections wherein I had produced persons similarly situated have been granted this benefit. These things were never examined by the tribunal, my lord. In fact, similar question, my lord, Madras High Court, my lord, I have filed a memo. Along with the memo, I have filed a judgment where the similar question was decided in favor of the employees, and High Court of Judicature has upheld the same. I have filed a memo, my lord, on 23
But
June.
tell us what was your claim before the tribunal?
Before the tribunal, my lord, your lordship may kindly see the prayer, my lord.
You see, show your writ petition.
Yes. Kindly see page number 31, my lord. To quash, my lord, the order, the direct response.
Now,
in
what was the ACP scale given to you?
The basically given was at 4,500, my lord. That is not correct. That is the page. I will point out that order, my lord. Your lordship can see.
One minute, please. Please just tell us what is the scale given to you as first ACP.
First ACP. That is
4,600.
my lord, 4,600. Your lordship will get it at. Kindly see. First ACP, my lord.
You show us the first ACP order.
Yes.
Merged, sir. It was merged as particular.
First ACP. My lord, page number 35. Page number 35, annexure even in pursuance of Government of India, Ministry of Personal Grievances 9899, and as per the recommendation of the screening committee, the below officials are granted financial upgradation under the ACP from 9899 as mentioned against their names.
So you were given 5,000, 9,000.
Yes, 5,500, 9,000, my lord.
What was the second ACP?
Second ACP, your lordship will get at page number 42, annexure A4, my lord.
Page 42.
42, my lord.
You were given 65,000, 10,500.
Yes, my lord, as against this, my lord. In the meanwhile, my lord, the petitioners had got promotion and the pay scale got revised with retrospective effect, my lord.
When did he get promotion?
Annexure A5, my lord, dated 6/2/2008. 6/2/2008, my lord.
6/2/2008. So no third ACP.
No third ACP, my lord. But in the meanwhile, annexure, what was done was annexure A6, my lord. Page number, my grievance is against A6 dated 4/4/2012, wherein on the recommendation of the screening committee and in pursuance of the Ministry of Personnel so and so dated 19/5/2009 and 9/9/2013, the following employees of DCO granted financial application under the MACP with effect from dated so and so. That is 19. This is whereas I had become due as on 1/1/2006 to 31/8/2006. Second ACP I have become due, my lord. 24 the completion of 24 years. Therefore, my lord, I made a grievance against the same. Annexure A7, my lord, my grievance was rejected.
When did you join the service?
1982, sir.
1982, my lord.
11.
I joined service in 1982, my lord. In 6/11/1982, my lord.
Now, what is this 46 page?
Well, 46 is they had given 24 your second MACP, my lord.
Not applicable.
It is not applicable to me, is my grievance. They gave MACP in the pay scale for 9,300 GP of 4,800, whereas I was entitled for second ACP of 24 years completion because it fell due between 1/1/2006 to 31/8/2006, my lord. So when this was done, I made a representation to the higher authorities, which was rejected as per annexure A7, page 47, my lord. Kindly see, my lord, for 1 minute. Then I will read out the grievance which I have made out also. Page number 47.
Now, if we have understood you,
yes, my lord.
Your grievance is that this second ACP which you got 6,500, 10,500.
Yes.
Is not in the right scale.
Yes, ma'am. That is exactly, ma'am. That is exactly.
What is the scale you are asking?
Yes, ma'am. That your lordship may kindly see my representation. Your lordship will find at page number 52. Entire grievance is captioned, my lord. Annexure A10, page number 52. It will make it clear, your lordship, my grievance, my lord. Because this I gave after I was wrongly given 24-year.
You tell us the scale instead of, you tell us the scale instead of 6,500, 10,500, which is the scale?
That scale were merged in
And this 6,500, is it a promotional scale or the next scale?
The pay scale was merged, my lord. It should have been given in the hierarchy, my lord. That is, kindly permit me for a minute, my lord, to read annexure A10, my lord. Kindly see. I have stated whatever your lordship asking, my lord. Kindly see. Your kind attention is invited to clarification of the Government of India dated 9/9/2010, dated so and so, and 10
See,
to
we just
2000.
want to know.
Yes.
What is the scale you got
for
6,500, 10,500?
Yes.
Can you hear us?
Yes, yes, I am hearing, my lord. I am hearing. I am hearing, my lord. I am hearing, my lord.
$3,400 as per the sixth pay conditions.
I am hearing, my lord. Now suddenly it has been. Your lordship tells you what in the page number 53, in the light of the clarification issued by Government of India DOPT, I had requested for grant of second ACP in the grade of 5,400. Your lordship asked me what scale. Yes, 5,400 with from the date of completion of 24 years of service, which is 6/11/2006. But the ORGA has not taken into consideration the above clarification issued by the DOPT while granting second ACP in the grade 4,800 with from 1/9/2008. Agreed by the ORGI, I have submitted representation. Now your kind attention is invited to the petitions in SLP number so and so, wherein Honorable Supreme Court has dismissed the upheld the judgment passed by Punjab and Haryana so and so. The eligible government servant as are placed in the immediate next higher grade pay in the hierarchy of the recommended revised pay band and grade pay, and not merely the next higher pay scale of as per the recommendation. This is exactly my grievance. Unfortunately, tribunal, my lord, did not consider all these questions. They said that you are not eligible. It is a frivolous case, and then. And I have enclosed
so
one
that we can
document.
also convey ourselves. Now tell us one thing.
Yes.
Is 5,000, you got 5,000, 9,000, the first ACP, second is 6,500, 10,500.
Yes.
That was merged as per this memos.
This was merged, my lord. Kindly come to 19 May 2009 official memorandum.
Yes, one minute. See, we can't hear you. There is an interruption here.
Then, my lord, I may submit a short date, my lord. I will come and personally argue. Better, because I should not trouble the court. I will personally come and argue because it involves fixation of pay. Next week, my lord.
We'll have it tomorrow.
Yes, I will prepare a entire synopsis and come to physically and.
Sir, tomorrow, sir, 1/8.
Yes, object.
Before, Srimati Nalini Venkatesh.
I appear for the petitioner organization, my lords.
But I represent the council for my lords, respondent number 3. So I seek indulgence of my lords 2 weeks in this case, my lords. ESGI appears, my lords, in this case.
What is the grievance in the?
My lords, if I may just state the facts in brief, my lord. Now, the petitioners have filed.
Yes, one minute. What is the difficulty?
Shanti Bhushan.
Okay. We'll have it after a week or 10 days.
10 days.
No, my lords, any date before August 8th, because after that I'll be out of the country for 2 weeks, my lord.
So we'll have it after 2 weeks. You
My
go,
lord, after
go and
August
come back.
24th,
Pardon?
after August 24th.
Oh, yes, we'll have it.
2-9, madam.
Which the other? 2-9.
We'll have it, we'll have it. Just give a date in September, any date.
2-9.
Much obliged.
25, CM Nagbhushan.
I appear for the applicants, my lords. The matter has been settled. I'll move a memo of withdrawal today before the.
We'll record your submission. You have settled.
Yes, my lords.
This is, you appear for?
For the appellant.
Appellant, for the appellant. You? Pardon? The dispute was against the private respondents.
My lords.
Very well, you also take instructions. We'll have it tomorrow. Get your memo tomorrow.
Pleasure.
At the request of counsel for the appellant, re-notify tomorrow.
26, Srimati Sudha.
Yeah. 36 days, which has been explained. Here on merits, the question is that, my lords, the appellant is the manufacturer of vinegar by using rectified spirit. Whether the rectified spirit, which is not potable in nature, can be subject of state tax in the form of license fee. I think I have to file a better paper book, only English version. There's a mixture of Kannada, English. Even I find it difficult to read. Now, if the delay is condoned and if the date is fixed for, because the larger interest is in, perhaps I think. Yes. Industrial alcohol covered by 7-judge judgment, another 3 or 4 judgment of the Honorable Supreme Court, that industrial alcohol cannot be a state subject. Entry 51 of 7th schedule list 2. Perhaps,
But was that plea taken?
yes, it is a main ground. Perhaps the learned single judge, perhaps interpreted in a different way. I'll take your lordship when it is. Because I was even thinking that learned advocate general may be there. State interest is also there. And another legal question I have put it that, my lord, based on the CAG report, unless it is placed before the committee of the legislature, Public Accounts Committee, it itself cannot be enforced. There is an authority on that also. One judgment is synthetic chemicals. The largest bench of the Honorable Supreme Court till recently, 7 judgment.
Who appears for the, you appear for all the respondents?
Yes, state authority. Delay may be condoned, I have explained it.
How much is the delay?
37 days of 30. What happened was the copy was supplied 37 days during summer vacation.
We'll condone the delay and you file your return submissions. This is an application filed under Section 5 of the Limitation Act, seeking condonation of 39 days delay in filing the appeal. For the reasons stated in the supporting affidavit, the delay of 39 days in filing the appeal is condoned. Application disposed of, counsel for the parties to file their written submissions along with the judgments they want to rely upon within 4 weeks.
Give me short one, because.
Just give it next.
3-9.
Please.
Case number 27. Rajshekar.
by
Yes.
invoking, my lords, the provisions of Official Secrets Act, my lords, 1923. An extent of, my lords, 4,000 acres was notified as, my lords, the
File objection.
notice already issued.
462.
5 years sent.
6 months.
This complaint appears to be in the nature of large scale allegations which are in relation to the encroachment of
Section 8. Section.
Section 8(1)(b) and 8(2)(b of the local act.
How would you answer that?
It's my respectful submission is, my lords, I can only bring it to the notice of, my lords, I brought it to the notice of Legal Services Authority also. I brought it to the notice of the government also. Then, my lords, I was asked to approach the Lokayukta, and I made, my lords, representation to the Lokayukta as well. Lords, their own report says, my lords, there are encroachers and revenue records are also mutated. It is for the, my lords, government and all, my lords may kindly see, my lords, when this matter was listed, my lords,
But how would this?
My lords, when
limitation or a
this
bar
matter was
under
listed,
18
my lords may kindly recollect. Lord suggested, my lords, when this matter was listed on the other, on the last occasion, my lords, Justice Rajeshri was the part of that bench, and my lords, this bench directed the government to secure the information and, my lords, make their submissions, what actions they have taken pursuant to their own record. The I'm sorry. Tahsildar's report says, my lords, there are encroaches.
You're right,
Yes.
but how would the report, scrutiny report, whatever is the report, it refers to provisions of section 8.
8, yes, my lords, yes.
How would be that particular stand which they have taken would be relevant, because this is statutory provision.
Now,
How would you interpret it, whether that could mean that it can be given a go by?
my lords, at least the Lokayukta could have referred the matter to the government, directing the government or requesting the government to, my lords, take action pursuant to the grievance made out by the petitioner. Lords, of course, in case if section 8 is coming in his way, my lords, instead of closing the matter, my lords, when a specific report is obtained by my lords, the Lokayukta itself, and he himself, the SP of my lords Mandya, has, my lord, submitted a report saying that there are encroachers, and, my lords, I have placed that also on record.
See, there is a provision, a sort of a Shall not conduct any investigation under the act.
Yes, but there is a provision.
What is that?
After A to D.
Yes. Provided that he may entertain a complaint.
Eight to D, my lords.
Because of course, not in his control also not to file this complaint.
My lords, the report, Tahsildar's report, inquiry officer's report, everything says.
How would you, no, there is a little window, you know.
Yes, yes, my lords.
That, no, if you say that, what are the reasons, and that says so. Entertain a complaint referred, and if the complainant satisfies.
Remand and
Complainant satisfies that
yes,
he
ma'am.
has sufficient cause for not making the complaint within the period specified in those.
May I suggest this, my lords? Let this matter be remanded to Lokayukta, my lords, with the direction to me to my lords,
Where
explain.
you must at least surely file an affidavit that these are the
Yes,
reasons.
yes, my lords.
That you will file it for us to even to be satisfied.
I will, my lords, I will ask my party to file, my lords. Yeah.
You must file. These are the reasons why.
Lords,
If we say so, because that would be an affidavit, maybe it was not there before them.
Yes,
Possibly then.
I will, my lords, sir.
So even sending, we must be
Yes, yes,
satisfied. This
yes,
provides the
yes,
complaint.
please. Yes, please. Ultimately, I am, my lords, exploring, my lords, some sort of public cause here, my lords.
Right. Given the provisions, he is right.
Yes.
I think that's a fair submission. That proviso has been brought to the notice.
Yes, yes.
When the counsel for the appellant seeks and is allowed 4 weeks to file an affidavit. In support of, to file an affidavit explaining the delay. Explaining the delay?
Yes.
Explaining the delay at his
So as to
request.
condone 8, section 8, subclause 1.
No, condoning the delay, no?
Yes.
Not condoning, explaining.
Explaining the delay.
Explaining the delay. We notify.
File 9.
Please.
The same be filed with a copy to the learner counsel for the respondents.
May I request, my lords, on 4-9, my lords, instead of 5-9.
It's at 4-9.
Great.
28 adjourned. Serial number 29. The approved.
29 appear for the appellant, my lord. In this case, I am challenging the judgment passed by the single judge, my lord. Wherein, my lord, respondents acquired my land, lord. In the year 1963, my lord. That is the preliminary notification in the year 1963 and final notification in the year 1969, my lord. And there was no compensation so far, my lord. And I filed a writ before this honorable court, my lord, at annexure D, my lord. Your lordship may kindly see at annexure D. That is page number 70, my lord. Actually, I am entitled for the compensation as per section 24 of the Acquisition Act 2013, not 1894, my lord. Because the award of compensation was awarded in the year 2014. That's so 1894 Act elapsed, my lord.
Who has the position? Who has the position?
Mysore Urban Development Authority, my lord, because it was acquired in the year.
They have the position.
No minutes. We have taken possession long back minutes. Their
Long
request
back,
is
and
for.
it is now become a city. It has become a city now, my lord. It is the heart of the city.
Just 1 minute. But tell us, why did you deposit in 2014 the compensation?
Milord, there is a reason, Milord. The petitioner had earlier approached this honorable court in WP 39216 of 2013, page 70, annexure D, Milord, is the order. Kindly see the operative portion of the order. Milord, page 74, paragraph number 6 of the order.
Yes.
May I read, Milord? Consequently, the petition is allowed. The respondents are directed to deposit the compensation in favor of the petitioner in a civil court as per law, treating the date of preliminary notification as 22/12/2009, which was the date on which the earlier petition were filed before this court by the other parties. Since the amount of compensation is not deposited over decades, and as the petitioner is only now being paid the said sum, the respondent shall pay cost of rupees 50,000 to the petitioner. Or in the alternative, the respondent shall allot a site in favor of the petitioner proportionate to the land that was acquired in any layout formed by the Mysore Urban Development Authority. Not pursuant to this order, an award has been passed, page 83, annexure F. Considering the preliminary notification as of the year 2009.
That is in the year 2014, award, my lord. 11/9/2014, after the lapse of the act. Now I am entitled for compensation.
This notice was
2013
served.
Act.
This notice was served to the petitioner, appellant, and in addition, cost of rupees 50,000 was also paid. It has been accepted. If they had any grievance,
Even the piece of land has been given?
no, my lords.
Proportionate land.
No, my lords. This honorable court has given an option, either pay compensation at the prevailing of, and the cost, or in the alternative to allot an alternate site. We have opted for payment of compensation considering the acquisition of the year 2009 and paid the cost of rupees 50,000. That has been accepted. Annexure F, page 83 is a notice of award. We intimated that we have determined the compensation in terms of this notice. If they had any grievance, they had a right to approach the civil court seeking reference under section 18(1). They did not do so. After 4 years, of issuance of this notice, writ petition has been filed in that is WP 546.
Annexure F is, my lord, in the year 2014.
Just 1 minute, let him complete his submissions.
Sorry.
Yes, we'll come back.
No.
Yes.
After 4 years, my lords, of issuance of annexure F, the writ petition 54673 of 2018 was filed, page 19, my lords. That is the order which is impugned here. The learned single judge of this honorable court finds that cost of rupees 50,000 is accepted, and the authorities have complied with the earlier direction of this honorable court. Therefore, they can't have any grievance over the determination of compensation. That order is under challenge. According my respectful submission is that the direction of this honorable court in the earlier writ petition is fully complied with. Therefore, there cannot be any grievance insofar as the determination of compensation. If they had any right, it was open for them to seek reference. They did not do so within 90 days.
Yes. What do you say?
Milord, the award has been passed at annexure F, that is on 11/9/2014, Milord. That is after the lapse of the Act 1894, Milord.
Just 1 minute. This date is incorrect, I suppose. Page 24.
Please, minutes.
This writ petition 39216/2013 is dated 7/3/2014. Okay. Yes.
Yes, 7/3/2014, correct.
Award has been passed, Milord, on 11/9/2014. That is after the lapse of the Act 1894. 1894 Act has been lapsed. Now.
But only one thing, but tell us one thing. Even what has been done by them is pursuant to the orders of this court. And that order is
cost of 50,000, they have issued a check. But my instruction is that the check has been returned by my party. And a meager amount of compensation was awarded. That is 1 lakh. And now my property is in the midst of Mysore city. Now it is in crores.
But did you seek enhancement of compensation?
No, my lord, because I have not sought. But now my contention is that they have awarded me compensation in the year 2014. that 1963 they acquired and compensation was awarded in the year 2014. That
Yes.
means the 1894 Act has been lapsed. Now I am entitled to compensation as per
But then-
2013 Act.
But then you should have challenged that judgment, previous judgment. See, the direction of the court was even after 1/1/2014 when the 13 Act had come into effect.
Yes.
So you should have said, look here, no such direction can be given. Now it's a new act which is there, old act has gone. But you
Yeah,
don't
yeah.
challenge it.
Only one submission, lads. The provisions of 2013 Act has no application to the acquisition made under the special enactments. This Honorable Court as well as by the Honorable Supreme Court have clarified.
So this is only to what he is arguing.
Please.
Yes. Yes, go ahead.
Yes, Miller. See, my contention is that I am now entitled for the compensation as per 2013 Act. 2013 Act has retrospective effect. It has the retrospective effect. So
But
I'm
tell us one
entitled.
thing. Now
Yeah.
let's test this argument of 2013. Initially, the line of judgments were either possession or compensation. One of them
Yes,
not
sir.
given, it lapses. Now the Supreme Court has in Constitution Bench clarified. Both need to be met. That's right. Then it is their case also that the possession has been taken long back. So
Yes,
how
sir.
would that provisions of new act will help you?
Not for
It will not
decades,
help you.
I have decades I have not been given compensation, my lord. 1963 acquired.
Then you must seek the enhancement. But annexure F is the compensation determined by you.
Yes.
Now he can
Yes,
seek
2014.
enhancement,
Now the
whatever may be. If the
Limitation has-
limitation, everything.
No, you will ask me grant him the liberty.
Nothing. It's
Please.
for him to seek a
Yes,
cause.
yes.
Yes. See, if you have a remedy, you will seek the enhancement of compensation. But today, even if you are arguing 2013, though has no bearing on the acquisition of the 1894 Act, even otherwise, the Supreme Court has now made it very clear. And it is a conceded position, possession was taken.
Yes, my lord.
So difficult. Okay.
So liberty may be
Yes.
liberty may be given to me for the enhancement.
We say nothing. Liberty, if in law you are entitled to, you can claim it. Surely you will seek your reference.
But the 2013 Act has the retrospective effect, my lord.
2013. How do we get
2013
that?
Act.
No. How do we get
Yes,
that?
yes, it has the retrospective effect.
This appeal has been filed by the appellant seeking challenge to the order dated 12 September 2020, passed by the learned single judge in writ petition number 54673 of 2018, whereby the learned single judge has dismissed the writ petition by stating in para 8 of the impugned order as under. Full stop. Suffice to state the facts relevant to be noted for the purpose of this appeal is that in terms of the respondents' authorities have issued a preliminary notification dated 19/12/1963, followed by a final notification dated 25/3/1969, acquiring the land belonging to the appellant herein. Full stop. The grievance of the appellant before the learned single judge was that he has not been paid compensation in furtherance of the aforesaid notification. Full stop. He had initially approached this court in writ petition number 39216 of 2013, and this court by day order dated 7/3/2014 disposed of the petition, inter alia directing to the respondent authorities to deposit the compensation in civil court as per law, with cost of rupees 50,000 to be payable to the appellant herein, or in the alternative, the respondent authority shall allot a site in favor of the appellant proportionate to the site that was acquired in terms of the aforesaid notifications. Full stop. Next. It is a matter of record that the appellant had made a representation to the respondent authorities dated 13/10/2024, produced seeking alternative site. Full stop. It was also stated in the that pursuant to the order of the court in writ petition 39216, comma, the no, just say this, 2014, seeking alternative site, full stop. It is the stand of the appellant in the writ petition that pursuant to the order passed by this court in 39216, 2013, the respondents' authorities have deposited the compensation amount under section 12 of the Land Acquisition Act 1897 before the civil court. Full stop. The submission of the case of the appellant before the learned single judge was that the compensation amount that has been deposited by the respondent authorities is inadequate, and compensation has to be deposited in terms of right to fair compensation and transparency in land acquisition, comma, Rehabilitation and Resettlement Act 2013, full stop. It was also stated that since a direction has been issued by this court to allot alternative site, as per alternative site, the same be considered in the writ petition. Full stop. On the other hand, the case of the respondents before the learned single judge was that they have deposited, comma, in terms of the order passed by this court in writ petition number 39216 of 2013, the compensation in the civil court with the cost as awarded by the learned, as awarded by the court of rupees 50,000. Full stop. And as such, the appellant cannot seek further compensation under the provisions of any other act. Full stop. Today, also, the learned counsel appearing for the appellant would make similar submissions in as much as the compensation which has been awarded to the appellant is inadequate, and the compensation having been paid in the year 2014 has to be under the Act of 2013 and not under the provisions of the Land Acquisition Act 1894. Full stop. On the other hand, the learned counsel for the respondents reiterate the submissions and justify the compensation as given to the petitioner appellant, along with the cost on the basis of the order passed by this court in the aforesaid writ petition. Full stop. Having heard the counsel for the parties, we are not in agreement with the submission made by the learned counsel for the appellant. Full stop. We find that the learned single judge was right in referring to the order passed by this court on 7/3/2014 in writ petition number 39216 of 2013. Full stop. Concedingly, the appellant has not challenged the order in a higher forum. Full stop. It follows that the said order has become final in as much as the respondents who were directed to deposit the compensation in the civil court along with cost of rupees 50,000 have complied with the order. Full stop. In fact, the plea of, insofar as the plea of the learned counsel for the appellant, that the appellant should be entitled to an alternative plot as directed by the learned, by this court in its order dated 7/3/2014 is concerned, comma, it is necessary to reproduce the relevant part of the order of the court in the order dated 7/3/2014, which gives a discretion to the respondents either to deposit the compensation along with cost of 50,000 to the petition to the appellant, or in the alternative, they shall allot a site in favor of the appellant proportionate to the land that was acquired. full stop. The respondents decided to accept the earlier part of the order of depositing the compensation along with cost of rupees 50,000 in the civil court. Full stop. So civil court. Having said that, insofar as the plea of the learned counsel for the appellant that the compensation having been deposited post 1/1/2014, yeah, under the new, just say under the new act of 2013, under the act of 2013, it necessarily has to be under that act, not under the old act of 1894. We are unable to accept such a plea, such a submission as well, for the reason that the compensation has been deposited by the respondents in terms of the directions given by this court on 7/3/2014, when the new act had already come into effect. If the petitioner had any grievance, appellant had any grievance with regard to such a direction, he should have challenged the same before a higher forum. Having not done that, and the said order having attained finality, we find no illegality in the order passed by the learned single judge, the appeal being without any merit dismissed.
Blank.
So the difficulty is yes.
Serial number 30. With the Sarojini Mukherjee.
Lordships, this is a case of misplaced principles of natural justice, thereby denying the workmen 17B wages. Umpteen number of adjournments have been sought, and finally an ex parte award was passed, which was challenged before this court. And I'm before this court with regard to the interim order and also the final order, which remands the matter back to the labor court. And again, the management is not in a position to conduct, they were supposed to bring their witnesses, bring their witness MW1 and examine on a particular day as per the order. But they failed to do that. And when they once again came before this court in writ petition, they filed a writ petition and sought the permission of the court to be permitted to lead evidence and conduct the case before the labor court. And now the at the when this order was passed, the workman was within the age of superannuation and he was reinstated with back wages. That was the order. But now after the matter was taken up before the labor court, again after this second writ petition was filed, the workmen reached the age of superannuation and only back wages and other benefits were.
After this remand, what is the position?
Your Lordships, thereafter there were the court passed orders.
Pass the order?
Yes.
What is the order passed?
Order passed is that reinstatement, no reinstatement, only back wages. And that is being challenged before this court. It is now pending in another writ petition.
Now then what survives in this?
Lordships?
What survives in this?
Lordships, is injustice done to the workman now that he has no reinstatement. So he cannot make a claim for 17B wages and he has to fight his case on an empty stomach, your Lordships. So the principles of natural justice has been misplaced.
He attained the age of superannuation.
Yes, yes. And he is a sick man and
see, you can't
carrying on a very difficult existence.
Right? You can't in any case go back because he has attained the age of superannuation.
Yes.
That's right. If he has attained the age of superannuation, you can't go back. There is no 17B.
Yes, there is no 17B. But before 17B was introduced, the courts were ordering interim relief to the workmen. So a similar thing could be done in this case because management can go on and on.
Best is you have challenged it before the learned single judge.
Yes, your Lordships.
That is under consideration there. Better you make a prayer there Today.
Your lordships, I cannot get 17B because I'm not reinstated.
You will not, that's right. That's what we are saying. You will not get 17B.
Yes,
You
your
must actually argue your writ petition and satisfy the court. 17B can't be given now.
yes.
So better would be you seek the early disposal of your writ petition. That's the best way. And this appeal, according to us, prima facie, has become infructuous. Nothing survives. The matter has gone. It has, award has been given. Nothing survives. You have to take a call.
Yes. Your lordships, but as such, principles of natural justice has been denied to him.
See, we don't want to really advise you. You have been given back wages. Have you accepted the back wages?
No, that is under challenge now.
You can say without prejudice, you accept some amount to sustain yourself. You can do it before the learner single judge.
Your lordships,
You're getting the point. You will, it's what we are saying, you can, unless and until what the other side say, we don't know. Back wages granted, you did not accept it, rightly so, because you have challenged it. Rightly so.
the management has challenged it, not the workman. Management has challenged. So this is in a continuous process where the management takes me to the court all the time.
You have not got the back wages also.
No back wages.
Better you go to the learner single judge, seek for an interim relief there. That's what I think best would be this, but surely this appeal doesn't survive. This doesn't survive. Take a call, you can think over it, we'll pass it over, come back after lunch. That's the best remedy, at least according to us.
Lordships, at least some time bound this thing for disposal maybe.
That you will make a request before the learner single judge. For an early disposal, you will make it. That's the best, well, that's according to us. So you take a call, what do you want? You want to withdraw this and pursue the remedy which they have filed, or the petition which they have filed?
Lordships, that automatically it has to be followed up.
Which one?
But as far as this is concerned,
Survives in this one.
the injustice to be principles of natural justice has been misplaced. So at least to that extent, so the workman gets some relief. He's carrying on a very difficult existence with his old age, and
Right, you got the.
he's depending on his daughters.
But you got the back wages, no?
Lordships?
The back wages.
No, back wages not paid. It is challenged.
It's under
It
challenge.
is, yes.
Better would be you must make a prayer before the learner single judge where that petition is pending. For at least granting you an interim relief. An interim relief. We don't know. You can maybe possibly take a call on 17B also. We don't know. You will take your seek every remedy which is available. I think, ma'am, this doesn't survive. I think better would be you withdraw this.
Yes, your lordship.
We will say so.
Yes.
Okay, this appeal has been filed by the appellant challenging the order dated 17th February 2023 of the learned single judge.
Dismiss it.
Petition number 12397/2018, whereby the learned single judge, while has disposed of the petition by stating as under this page 38. We have been informed by the learned counsel for the appellant that pursuant to the order of the learned single judge, the labor court has decided the reference number 24 of 2015 and MA number 4 of 2017. That's right?
Yes.
Full stop. Whereby the labor court has granted back wages to the appellant herein without any order of reinstatement. he concedes to the fact that the said order award of the labor court is under challenge by the respondent herein. Before in a
Yes.
petition which is pending consideration before the learned single judge. In writ petition number
Petition number WP number 3962. 3962 of 24.
and as such, she wishes to withdraw the present appeal. Noting the said submission made by the learned counsel for the appellant, this petition is dismissed as withdrawn.
Then sir, 21 days short.
Yes.
Please. 31, serial number 30.
My lord, I appear for the appellant.
Present,
My lord, the
respondent.
corporation, my lord, is in appeal. The matter pertains to, my lord, appointment on the compassionate grounds. My lord, the father of the writ petitioner passed away, my lord, on 20th of June 2008. Thereafter, my lord, an application was filed seeking appointment on the compassionate grounds. My lord, that application, my lord, came to be rejected as early as in the year 2009. My lord, with a order at Annexure F, page number 33. We stated that he has not attained the majority within 1 year after the demise of the father. And as per Rule 5, he is not entitled to seek compassionate appointment. This happened in the year 2009. Thereafter, my lord, for 9 long years, nothing would transpire. 2018, an application would be filed by the mother of the petitioner to the corporation, seeking appointment on the compassionate grounds.
They're also filed
Mother on behalf of the son.
after 9 years.
After 9 years, in the year 2018.
Indeed, majority.
Please. My lord, no, he attained the majority in the year 2009 itself. Please. So after 10 years, my lord, after the demise of the workman, the second time, my lord, an application came to be filed in the year 2018. They rejected it, my lord, by issuing the endorsement at Annexure A and stated that we cannot consider it because it transgresses Rule 5. 28/3/2018, my lord, endorsement was issued. My lord, Rule 5, my lord, contemplates 2 things. My lord, if at all he is a minor, the person who is seeking appointment on compassionate grounds is a minor, then, my lord, he must file an application within 1 year. He must attain majority within 1 year of his father dying. And the application must be filed 1 year thereafter. This is the rule.
After he attains majority.
After he attains majority. He must attain majority within 1 year of the demise of the father, which he did not, admittedly. Now, 2018, we issue this endorsement. 2021, he files a writ petition challenging, my lord, the 2018 endorsement. That earlier endorsement has already attained finality, 2009 one. Now, before the learned single judge, my lord, one order, my lord, is pressed into service. As an exceptional circumstance, my lord.
Yes.
My lord, as an exceptional circumstance, the learned single judge in another case, my lord, had taken a view that hardly there was 40 days delay in that case. And hence, my lord, he had directed the corporation to reconsider the case. My lord, that was pressed into service before the learned single judge. And now, my lord, by the impugned order, in the light of the other judgment, my lord, we have been directed to consider the case for compassionate appointment. Now, my lord, the rejection order of the year 2009 is never challenged. And a lot of time, my lord, have passed. The very purpose of...
Yes, yes. Please say.
Yes, Lords, so the contention that, my lords, we have not pursued pursuant to the rejection order in the year 2009. Not correct, my lords. We have addressed a letter to the government also. My lords, hardly 21 days. In the other case, my lords, it is 40 days.
Even forget this limitation aspect.
Yes.
What is the purpose of compassionate appointment?
So it is for the benefit of the family, my lords.
Tie over a situation which has arisen because of the death of the family
Lords,
member.
my contention is,
The earning member.
yes, even after my lords lapse of 9 years, my lords, we were forced to, my lords, face the difficulties. That is why we were pursuing with,
From 2009, you did not take any action. Surely you are a person who was.
2010
well-
also, we were pursuing with, my lords, the government.
That's the intent.
That's right, my lord.
And N number of cases.
Lords.
That it should be at the first instance. Now tell us what were the benefits you got after the death of the father? How much benefit he got? The family got?
Nothing.
How can that be?
My lords,
When an earning employee expires, there are benefits which are given.
Yes, my lord, please.
Did you look into that?
That, my lord. will
How
have
many
to-
years of service he had put in?
he had put in, my lords,
For how many years, for what was the length of service before
my
he
lords,
expired?
my lords, length of service, my lords, we have not mentioned, my lords, in the.
These are cases where, that's right. The harsh case, they can't survive. The earning member has expired.
2008 onwards, my lords, we have been pursuing.
And so surely at least when you must be having at least 10 years of service.
Yes.
Although the date is not clear from the
Not
record.
clear, my lords.
But the explanation for not challenging 2009 when the initial rejection was there
May I request my lords to turn to,
possibly will not help you.
may I request my lords to turn to annexure G, my lords, for a moment, page 35, page 35. Lords, pursuant to
Yes.
the order, my lords, we have requested the government also to reconsider our case, my lords.
What is the date of this 2010?
17/5/2010.
When did you file the petition?
My lords, subsequently, we have made representation, my lords, in the year 2018.
Will not extend. You have approached the court in 18. You
I
could have
have-
done it in 2010.
I have
That's what we
approached,
want to say.
I have approached in the year 2021.
See, that really shows there was no such urgency to have the means.
My lords, may I request, my lords, what ultimately, my lords, the learned single judge has only said, my lords, you consider my case afresh.
No, but tell us why that consideration should be given. You must say, there may be harsh cases
Please,
where there may be penury, there are no means of sustenance, small children, the wife, a widow.
look at,
Can't get any employment. Those are the cases.
look at my situation also, my lords. I was just 17-year-old by then,
A young man in the sense that he was 18 years when he applied.
applied, my lords. Now he is 27 years, my lords.
I don't think we should take it further,
Please, my lords.
not in these facts.
It's, Immediately, my lords, just 21 days is causing, my lords, lot of, my lords.
21 days.
Please.
We are only between 2009 and 2018.
My lords, my respectful submission.
Convincing, we can't.
My lords, my respectful submission is, my lords, we have been pursuing with the, my lords, authorities and, my lords, even with the government also. So since the government has not taken any decision, my lords, we were forced to, my lords.
It should be a more, a better case. On fact, we will definitely. And it's not like that. There is a purpose for this scheme also.
That's right, my lords. So
Not
as
in
to
this
bring
taxation.
solace to the family, my lords.
Right. But there is a quota also of 5%.
Yes, please.
There is a quota.
There
Now,
is-
difficulty is what happening is the cases which may not be deserving, they occupy 5%. And the moment 5% is achieved, the deserving cases go back.
At least let them consider, my lords, now
Not in this.
whether, my lords, I am gainfully employed subsequently or not. My lord. Let them take a call, my lords. That's what learned single judge has done.
No, not in this.
Long way to go, my lords. I'm just 27, 28 years.
You are right. Just imagine against this, there may be a more harsh case or more a case which is more difficult. The purpose is only to. those
My respectful submission is, my lords, 21 days should not come in the way of, my lords.
Forget 21 days. We are
Yes.
not even looking at 21 days.
If I had not approached the government, my lords, then yes, my lords, I have no case. Otherwise, since here is a case where, my lords, I have approached the government, also the authorities, including respondent number 2.
There is no
Even the-
endorsement at all. to the government.
Even so.
There is no endorsement, my lord. They are showing.
We have seen that.
Yes.
The appeal has been filed. Challenging the order dated 28 March 2020.
May make one. My lords, the contention of the government that there is no endorsement cannot be, my lords, accepted because they have only addressed a letter.
We say they have rightly received it. They did not apply, they did not consider it, but nothing precluded you to come to the court then. In petition 18925 or 21, whereby the learned single judge has disposed of the petition filed by the respondent herein by stating stating as under page 12 and 13. The case of the respondent before the learned single judge was challenging the endorsement dated 28/3/2018 of the appellant herein, whereby the appellant has rejected the application filed by the respondent herein for compassionate appointment on the death of his father on 26/2008. The said endorsement reads as under 22/23. Yes, we said. It is a conceded fact that the father of the respondent who was working as water pump operator died on 26/2008. It appears that the appellant made an application seeking appointment under compassionate ground, which was rejected on 28/3/2018 on the ground that the appellant was 21 days younger than the age of majority, as which he was required to fulfill to get an appointment in the government. Stop. The submission of learned counsel for the appellant is that as per Rule 5 of the Rule 5(1) of Karnataka Civil Service compassionate recruitment rules, contemplates
Responding to.
that if the applicant had not completed 18 years within 1 year from the date of death of the father or the father, he can, on attaining the age of majority, apply for compassionate appointment within 1 year thereafter. His submission is also that in terms of the communication dated, which was the rejection in 2009,
My lord, annexure F, page 33.
page 30.
33.
In terms of communication dated 31/1/2009, the appellant had informed the applicant, that is the respondent, informed the respondent that his request for compassionate appointment cannot be granted. Full stop. It's a considered position. According to him, the respondent had not challenged the said communication in any court of law. It is only in the year 2018, upon endorsement dated 28/3/2018, that the respondent had approached this court. He submits that the endorsement dated 28/3/2018 makes it clear that in terms of Rule 5(1) of the rules referred to above, the respondent was required to file a request for compassionate appointment within 1 year which the respondent did not do. As such, they have rightly rejected appellants have rightly rejected the request for the appellant. Respondent number.
Even in first and second paragraph, it is mentioned as appellant.
He submits that the Rule 5 being a statutory nature is required to be followed and adhered to, and as such, no indulgence can be shown by this court, and as such, the learned single judge would not have given the direction in the manner he has done in the impugned order. He prays that the order of the learned single judge be set aside, otherwise the same shall form a precedent, making the Rule 5(1) as otiose. On the other hand, learned counsel for the respondent would contend that the learned single judge is right in directing, would contend that the only direction given by the learned single judge is to consider the case of the respondent for grant of compassionate appointment. In that sense, according to him, in that sense, there is no direction by the learned single judge to grant to the appellants to grant compassionate appointment to the respondent, and as such, the direction given be not interfered with. That apart, on the plea of the learned counsel for the appellant, that the appellant had not challenged the communication dated
31/1/2009.
31/1/2009 till the filing of the writ petition, and the same till the filing of the writ petition in 2018 is concerned. He submits that the respondent had made representations to the government, but had not heard anything positive from the government on those representations. And it is after the communication, after the endorsement dated 28/3/2018, that the respondent had approached the learned single judge in challenging the said order, and as such, there is no, and as such, the delay which has occurred cannot be attributed to the respondent. We are unable to agree with the submission made by the learned counsel for the respondent, for the simple reason that in terms of Rule 9, Rule 5, one of the rules which have been referred above, it is true that the respondent was a minor when the father had died on 28/3/2018. On
26/2008.
2008, but the rules also stipulate that he is required to make an application within 1 year of his attaining the age of majority. Concedingly, no such application was made by the respondent seeking compassionate appointment.
We have
Even we find that
have made the
it is the
we have made the application. They have rejected our contention saying that I have not attained the age of majority.
Yeah, it is true that the appellant respondent had made a representation, but that was before he had attained the age of majority. And thereafter, the respondent have communicated the decision in the year 2009 on
31/9.
31/9/2009. The said order clearly required the respondent to apply for compassionate appointment within 1 year of his attaining the age of majority, which concedingly he has not done. The case of the respondent is that he made representations to the government which have not been answered to, but the same would not explain the inability of the respondent to approach a court of law immediately on the receipt of communication dated 2009 or make an application for compassionate appointment within 1 year of the attaining the age of majority. The scheme for grant of compassionate appointment is only to for tying over a situation which has arisen because of the death of an earning member in the family. The fact that the respondent did not care to approach the court for almost a period of 9 years shows that there was no urgency, shows that the family was not in a situation which required a grant of a compassionate appointment for a member of the family. We are of the view that the learned single judge has not appreciated the opposite fact which we have stated above. And also the effect of the rule 5(1) of the rules, which being a statutory rule was required to be followed by the respondent. If a person does not adhere to the requirement of rule 5(1), we are afraid that a request for compassionate appointment beyond the period stipulated under rule 5(1) cannot be acted upon. The directions of the learned single judge for consideration of the application of the respondent in terms of the impugned order is concerned. The said directions shall be at variance with the rule 5(1) of the rules of which a reference has been given above. And the said rule being a statutory rule, it need to be given effect to in letter and spirit. In view of our submissions, in view of our discussion about, we are of the view that the directions of the learned single judge are clearly untenable, and as such, the order passed by the learned single judge is liable to be set aside. It is ordered accordingly. The appeal is disposed of.
Okay.
No cost. Thank you.
32. Chetan Shetty.
Lords, I appear for the appellant. In this case, the appellant was a senior manager of the respondent bank, and for some alleged misconduct, he was terminated from service as per Annexure A. And before his termination, he was under suspension for some period of time. Now he preferred gratuity application as per page 54 to 60, in claiming the payment of gratuity as per the Payment of Gratuity Act, and also giving the option of payment of gratuity as per the erstwhile bank's rules. As per section 4(5) of the Act, he is entitled to get a better terms of gratuity. But learned single judge has told that because the employee has been terminated from service, he is not entitled to get better terms of gratuity under the bank's gratuity rules. But my lord, in this case, the Payment of Gratuity Act has not differentiated between persons who are terminated or retired under superannuation, because they have defined very clearly, retirement means termination in any manner and superannuation is different. So the only grounds on which the gratuity can be forfeited is under 4(6)(a) or B. We say that for financial loss cost to the bank or for moral turpitude. Both are not present in this case. And the controlling authority has paid the gratuity as per the Payment of Gratuity Act with a ceiling of 3.50 lakhs. He would have got around 4,61,000 on his date of termination. Now, my lord, this honorable single judges erroneously relied on the question of law decided by the Honorable Supreme Court in the case of Beed District Central Cooperative Bank. In that judgment, the Honorable Supreme Court had decided the matter which is particular to that case, because in that case, the employees wanted the basic salary as per this one and gratuity as per another rule and the number of days as per another rule. In that context, they said, but Honorable Supreme Court in the case of YK Singla versus PNB, Punjab National Bank, has allowably dealt with Section 4(5), at para 120 and 26, and a test should be given. So, my lords, this may.
Plus one thing, once there is a gratuity act and there are rules.
Yes.
Now, if you are otherwise, if you had superannuated, you would have get pension and retirement benefits in terms of the rules.
Yes, my lord.
The gratuity would not be under the Gratuity Act because you have the rules now.
No, my lord, Section 14 of the Payment of Gratuity and Section 4 of the Payment of Gratuity is most important. Section 4(5) of the Act, 4 within bracket, says better terms of gratuity you are entitled if it is under this one.
That's
Section 14 of the Act, it says that all the provisions of the Payment of Gratuity Acts overrides any other rules or law, other things. So, my lords, in the YK Singla case, which I am referring.
So we want to this. If there was nothing against you, there was no proceedings against you. If you had retired,
Yes.
you would have got gratuity under what provisions?
No, you would have got to better terms under the payment of, bank's rules.
Right?
Yes.
So let's proceed on that premise.
Hmm.
The better terms is the bank rules.
Yes.
That's right. Also, that should be the position in terms of, I think, 14 also. If there are better terms than what is entitled to under the Payment of Gratuity Act, that will prevail.
Yes, my lord. But here bank rule is better to me. The learned single just simply rejected, saying that just because I am terminated from service, I am not entitled for gratuity.
Yes, the
But,
reasoning is, that's what I think we should agree. Because the bank rules also contemplate, if it is a case of termination, you will forfeit everything.
No,
is it right?
No. Because one thing is, second thing is, the bank rule also says that if the provisions of that rules is in any way repugnant to the any other law, then to that extent it's void. Even the bank rule says. So the bank rules also do not say that correctly, that if anybody is terminated, he is not entitled.
Doesn't say so.
Doesn't so specifically. But they said, if the provisions of these rules of the bank is opposite to the any law, including Payment of Gratuity Act, to that it is void. Now, within the end, Payment of Gratuity Act also not different.
Tell us one thing, then why didn't they pay you gratuity under the service rules?
Service rules, they said, no, actually he claimed through after termination of service only. But there was some confusion because before termination of service, he was under suspension for 1.5 years. So that was required to be taken as a service because Section 2(a) of the Payment of Gratuity Act specifically says that if the service as an employee is not terminated, and that period cannot be excluded, one thing. Then another thing is,
But your claim is under the Payment of Gratuity Act.
no, payment of gratuity within the bracket 4(5), Section 4(5), better terms. And no, it's for under the rules only because.
So we want to know, you were terminated, but were you entitled to gratuity upon termination?
Yes.
Under which rule?
Under Payment of Gratuity Act.
Not under Payment of Gratuity. See, that's what we want to convey to you. If you were to retire in normal course from the service, you would have been paid pension and gratuity.
Yes.
Under which provisions? Under the rules?
Bank rules, yes.
Bank rules?
Hmm.
Now, but it is a case of termination.
Yes.
If it is a case of termination, does the bank rule, even upon termination, why didn't they pay you gratuity?
They are not, because they said the termination, you are not entitled.
That's right. That's what we want to convey. Termination entails forfeiture.
No, my lord, it's section 4.5 and YK single case of honorable.
Come to 4.5. Let's keep 4.5 aside for a minute. We are only on the service rules. We want to know what is the position under the service rules.
Service rule does not say that he will forfeit the graduate.
Very good. But it also contemplates that he will not be paid the gratuity.
He may not be paid the graduate.
It's as good as forfeiture.
No, he may not be paid the graduate.
So he is not paid. So you went to controlling authority saying that, look here, I am entitled to, even they are not paying under the service rules, under the Payment of Gratuity Act, I am entitled to get the gratuity.
And also under section 4.5 better terms, under the bank rules.
So you are entitled to. The controlling authority accepted your submission.
Yes, my lord, yes.
And granted the gratuity.
As per the payment of graduate.
As per the payment of
with the
gratuity.
ceiling of 3.50 lakhs.
They went in appeal to the appellate authority or to the High Court?
Appellate authority.
Appellate authority reversed it.
No, he said that payment of gratuity only. He passed erroneous judgment that controlling authority has no jurisdiction to decide on this issue. He relied on a wrong judgment, another wrong judgment, Allahabad Bank case. Then I challenged before the Honorable Learned Single Judge in writ petition. Appellate authority relied on wrong judgment saying that controlling authority has no jurisdiction to decide on the eligibility or otherwise.
Now, how would you answer this? If you are governed by service rules, then the applicability of Gratuity Act is outstood.
My lord, see the service rule itself says that, graduate rule itself says that, if the provisions of
So just why it appears what he is saying is, so rules and Gratuity Act, you are governed by the rules, but you did not get gratuity, you went under the Gratuity Act. Now, between the rules and Gratuity Act, once the rules have been made applicable, will the Gratuity Act applicable to you?
Both, because as per the my lord, this YK Singla judgment is very clear on that subject. I am giving this YK Singla judgment. That is para 21 to 26. Then just not para 21 to 26 at page internal page 486 onwards, and internal page 486, that's page number 8 of the judgments. The most important question which arises for our consideration is whether the provisions of the Gratuity Act can be extended to the appellant so as to award him interest under section 13A of section 7 of the Gratuity Act. Insofar as the instant aspect of the matter is concerned, it was a vehement contention of learned counsel appearing on behalf of the appellant that the provisions of the Gratuity Act are extendable to the appellant. and as such, he would be entitled for disbursement of interest under section 73 thereof. The plea of the behest of PNB, however, was to the contrary. The contention of the learned counsel representing PNB
Being adopted 1995 regulation, the claim of the applicant is being.
there's a pension regulations of that concerned bank, my lords.
You have seen this judgment?
Yes, Lord. Lord, there are.
Come back.
Yes.
Come back.
Bill number 32.
No, single edge refer to the judgment of the Honorable Beat District, Honorable judgment of the Honorable Supreme Court in the Beat District, second judgment in this list. In that,
Let's see that judgment.
it is at page 10 to 16, that is this one. In that para 5, it said what is decided in that case. It is only because the employees wanted the basic drawn of one organization, dealing with another organization, dealing with this one. They said it's a salary package is single. That is decided there, not to this whether applicable to 4, 5. That is a 10 to 16 pages. Para 5, what is decided there? Para 5 page 13 minutes.
Singla is only on interest.
No, interest in the sense applicability of the payment of graduate tax to the rules of the bank, because there is a refer to the pension regulations, 1975. That says that if the disciplinary proceedings is pending on the date of termination of service, gratuity can be withheld. In that they have clarified that we are not going whether they can withhold or not. But if at all they withheld, whether the interest is payable, because that regulation is silent on that. So they extended.
Interest is more beneficial under the gratuity act.
Gratuity act.
So even the better of it should be given.
Going to them.
But service regulations in any case are better to you as compared to gratuity act.
Because gratuity act they should give to us. Because there cannot be discrimination between terminated employee and superannuated employee. There cannot be discrimination because the act itself, payment of gratuity itself has not discriminated between the persons who are terminated from service or who are superannuated from service. No, rules, because they said that anything repugnant to the payment of gratuity, that to that extent is void. And section 14 of the payment.
This issue has not been decided.
No, section 14 of the Gratuity Act is
You've seen that. What you are arguing is, Gratuity Act only contemplates two eventualities. One is moral turpitude. That's right.
financial loss.
And financial loss are the only grounds when the gratuity can be stopped.
Stop
That's all. No other eventuality.
No anything.
That's what you think. It is not a case of moral turpitude.
Nor financial loss. Financial loss.
What is?
My lord, there are both the scheme as well as the act, my lord, operates here, my lord. My lord, initially, my lord, few facts, my lord, before delving into these judgments, my lord. My lord, he was terminated from the services with some misconduct. Then, my lord, he challenged that order before this honorable court. Meantime, my lord, he filed application before the controlling authority for gratuity. That was rejected on the ground, my lord, the judicial proceedings are still pending. Then, my lord, after conclusion of the judicial proceedings here, he filed another application before the controlling authority. Then, my lord, controlling authority decided that he is entitled for gratuity under the Payment of Gratuity Act. Simultaneously, he also made a plea before the controlling authority, an additional ground, that, my lord, he is entitled for better terms under the bank fund schemes. Controlling authority, my lord, rejected that ground, my lord, and said, my lord, because since he was terminated from the services of the bank, and under that scheme, my lord, the eligibility to grant gratuity is to be, my lord, he should not have been terminated by way of punishment. So, taking that in reliance on board, my lord, the controlling authority rejected his scheme. Then, my lord, he challenged before that order was challenged in appeal. Appeal also confirmed, my lord. Before the single judge, my lord, that also is confirmed. Now, the question, my lord, this issue is clearly covered by the Beat District case. Because Beat District case itself says that if there are two contracts, one is an act and another is a scheme, but that two contracts has to be looked into an entirety. There cannot be a dissection of these two schemes and looked into taking some beneficial provisions of that contract and some beneficial provisions of the Gratuity Act. Because that will amount to forming a different scheme altogether. So Beat District case is clearly said, my lord, since there are two separate schemes, which is because it's a choice of the workman to opt either of the two schemes under the better terms of section 4.5. So when there is a choice for him, either of the two schemes has to be made applicable as a package. That is what the Beat District case is clearly said. Then now his case is before the first learned single judge and also before this court is, we have to only take the quantum of the scheme has to be taken into consideration, not the entitlement. But that is also not correct because following this Beat District case, the subsequent judgment of Ajay Babu case, that also is very clearly says, even entire contract in the sense, it also covers the entitlement of the workman for claiming gratuity. But you also kindly see that judgment, I will just pass on. Yes.
That termination is not a aspect which would entail forfeiture of the complete gratuity or doesn't pay the gratuity.
There is no dispute about that. Yes, that is true, my lord. Now what he has been denied under the scheme, what he claims is he wants the better gratuity under the scheme, not under the act. Because under the act, my lord, he has been paid 3.5 lakhs, 3,50,000 rupees he has already received. Now he says under the act, payment of gratuity act, he has received that. Well, the order passed by the controlling authority, my lord. Yes, that has been implemented, my lord. That order has been implemented.
Even though he was terminated under the service rules, he is not entitled to.
No, under the service rules, we have not paid because he claims under the service rules. He claims the gratuity under the service rules. Under the service rules, he is not entitled, my lord, for gratuity as per that scheme. Yes, under the act. Because his entitlement for gratuity cannot be, my lord, curtailed under the service rules. That is only a parallel act, my lord, which to offer a better choice for the employees. That doesn't mean that, my lord, as per section 14 and 5 of the Gratuity Act, because, my lord, if any scheme disentitles a person from gratuity, then it goes inconsistent to the Gratuity Act. Here, my lord, since the Gratuity Act is already operating for him, we have paid under that act. Now he is seeking better benefit under the terms. Because, my lord, because under section 5, my lord, section 5 of the Gratuity Act, there is a provision, my lord, for exemption. There is no, we are not exempted from the Gratuity Act. We are not exempted. Since parallelly there are two schemes operating.
A person retires in normal. Would you give him under the service rules and also under the Gratuity Act?
Under the normal, suppose if a person superannuates normal course, my lord, there are two calculations will put before him. Two determinations of gratuity will put before him, my lord. Whichever is higher, my lord, that will pay to him. That is the procedure, my lord, which has been adopted. No, both are not applicable. Whichever is higher, my lord, that will be applicable. Forfeited. Under the Gratuity Act, my lord. That is the difference. Because YK Singla case.
What is his claim subsisting now?
No, there is no claim asset pending, Lord. Yes, challenge.
Maybe better terms because I am entitled because there is no discrimination as per the even payment of Gratuity Act between terminate this thing.
What do you want now? What remains?
I want the difference amount payable as per the graduate rules of the bank.
As per the
graduate rules of the bank because I am entitled for another 1 lakh more.
Now tell us then, so we will see what are the rules. Then we have to see what are the rules. Now does the rules contemplate forfeiture?
Rules says, 12E of the rule says, if a person is terminated by way of punishment, he is not entitled for gratuity. He is not entitled for that.
No, Lord, actually that rule itself says that if the rules are against any law, which in this case is payment of Gratuity Act, then that rule to that extent is redundant. The rule itself says.
Right.
Now,
whatever your entitlement under the payment of gratuity, you got it.
Yes.
Now you are coming back to the rules.
No, in the earlier itself, I asked the better terms I asked. In the earlier, my first application itself asked, because I made two calculations as in the case of superannuated employee, and I asked better terms.
Let's put it this way, let's rephrase our question. This extra 1 lakh, you are claiming because of the rules?
Rules, yes.
And the rules are not applicable here. When in terms of the rules, you forfeit the complete gratuity, can you be paid 1 lakh?
No, there is no forfeiture clause. My lord, the rules are stated in pages 77 to 99. They say who is entitled. There is no question of forfeiture there.
You can't have both. One you have to choose.
Rule 7712 is here. They are referring to rule 77 at page.
Yes, I don't think we should take it further. The learner single judge is right.
Because the judgment relied is for that purpose, because the section para 5 of the B district says that the employees in that case wanted the basic draw of their employer, dearness as per the payment of gratuity, and ceiling as per the employer. This thing.
You can't travel, you can't have both the best of both. The intent is only one. You got the benefit of the Gratuity Act. You can't now claim the difference of the amount of.
No, first itself it was claimed actually.
My lord, one paragraph, my lord, that YK Singla case, my lord, very clearly it is said, my lord. My lord, in that judgment, my lord, which I just now provided, my lord. That second judgment, my lord, which is the yes, page 12, my lord. But I just now the paper book, my lord, the compilation which I just now some in page 12, my lord. In page 12, my lord. My lord, the Union of India versus CH-2 above that, my lord, para 11. The Learned Counsel for the Appellant Bank submits that subsection 5 of section 4, while providing for better terms of gratuity, or any award or agreement or contract, deals only with quantum of gratuity and not with entitlement under any award or agreement or contract as such. We are afraid this submission cannot be appreciated. The statute provides for better terms of gratuity under any award or agreement or contract, which means all terms of contract. The choice is between the award or agreement or contract and the statute, but not partially of either. Then, my lord, the B district is also referred here, my lord, subsequently.
No, page 90 of the regular rules says this one. When the admissible, they say gratuity is payable on such and such eventually, page 90, the rules of the bank. It says that his services in the bank is terminated by the bank after 10 years of continuous service. He's entitled to this.
Tell us one thing. The employer has not framed any gratuity. How much you would have got it? 3.5 lakhs. Which you got it? Which you got it?
3.53 lakh go.
The moment a case of termination, the employer will not see towards his rules. He says under this rule, this cannot be operated in your favor. And rightly so, because it contemplates forfeiture. The challenge is appeal. Petition filed by the appellant hearing by stating as page 26, para 17, this is para 17. The challenge in the petition was the opposite petition was filed by the appellant before by challenging the order 24/1/2017 of the controlling authority. under the Payment of Gratuity Act, and the order date is 29/12/2017, passed by the appellate authority under the same act. Full stop. The facts which are relevant for a decision in this appeal are the appellant joined the service of the respondent number 1 bank in the year 1971. Full stop. Due to certain irregularities committed while working at the bank Bijapur office, he was placed under suspension during the period 10/6/2005 to 23/2007. The charge sheet was issued for the proceedings were held and which resulted in the dismissal from service in terms of the order passed by the disciplinary authority. The departmental remedies, departmental remedy before the appellate authority also resulted in a rejection. The appellant filed an application under section 7 of the Payment of Gratuity Act, claiming gratuity from the bank. The controlling authority dismissed the claim as being premature by reserving the liberty to prefer the same after the proceedings in writ petition number 16150, wherein the petitioner had challenged in his dismissal. Appellant had challenged his dismissal from service for failure. The appellant, after retaining the aid of superannuation, filed a similar application for payment of gratuity before the controlling authority. So the controlling authority, on the same ground, again rejected, again closed the writ petition, again closed the application. A subsequent writ petition being 10904 of 2015 was allowed, and the order of the gratuity of controlling authority who had rejected the application of the appellant was allowed, and directing the controlling authority to dispose of the application within a period of 2 months from the date of receipt of the order. The controlling authority directed the bank. The controlling authority, within its order dated 24/1/2017, directed the bank to pay the gratuity amount of ₹3,50,000 along with simple interest at the rate of 10% per annum, with effect from 5/5/2009 till the date of payment. It may be stated here, there is no dispute that the said amount of 3,50,000 along with interest you pay.
Yes, yes, paid.
Along with the
interest.
paid to the appellant. The appellant, being agreed by the order of the controlling authority, not granting better terms of the gratuity, had filed an appeal before the appellate authority. The appellate authority confirmed the order of the controlling authority. The case of the appellant before the single judge was that the order passed by the controlling authority under is against the interest of the appellant, as the appellant is entitled to better terms of gratuity, amount payable to him in view of the provisions of the Payment of Gratuity Act.
Rules, not act.
In terms of
Better.
12E,
Yes, yes.
12E of the rules of the Payment of Gratuity rules. In this regard, it was the stand of the appellant that even if the appellant is terminated from service from in this regard, it was stated that that the rules, the gratuity rules under the Payment of Gratuity Act do not specify exclusion of the employees who have been terminated from service to receive gratuity. This term. Receive gratuity. On the other hand, the case of the bank before the single judge was that the issue which had been raised by the appellant is covered by the judgment of the Supreme Court in the case of Union Bank of India and others versus CG Ajay Babu and another, reported in 2018 9 SCC 529, and B the District Central Cooperative Bank Limited versus State of Maharashtra and others, 2006 8 SCC 514. So in other words, the case of the respondent bank was that the appellant having got the amount of 3,50,000 with interest pursuant to the orders of the controlling authority, the appellant the appellant is not entitled to any benefits under the service rules, more so under the service rules governing gratuity, more so when the service rules stipulate on termination the employee forfeits the gratuity. The learner single judge on in paragraph 11 to 15, 11 to 16, while rejecting the, so you said the learner single judge while rejecting the case set up by the appellant as in paragraphs 11 to 16 stated as under. Even before us, the submission of further counsel for the appellant is on similar lines as was the case set up before the learned single judge. Full stop. The single judge. He also relied upon the following judgments in support of his submissions. Full stop. We are afraid that the submissions made by the learned counsel for the appellant cannot be accepted. More so in view of the position of law as laid down by the Supreme Court in the District Central Cooperative Bank Limited Supra, wherein the learned of which a reference has been made by the learned to paragraph 14 of the judgment. The conclusion drawn by the learned single judge based on the judgment in the District Central Cooperative Bank Limited is that the material on report to be that as per clause 12B of the regulations, the workman is not entitled to claim under the said provision, since the workman ceases to be an officer of the bank on account of punishment imposed on him. Punishment, let's say, don't say officer, was imposed on him. And in the case in hand, when the appellant could terminate it, there is no question of entitlement of better terms of gratuity under the service regulations. So we agree with the aforesaid conclusion drawn by the learned single judge. If the plea of the learned counsel for the appellant has to be accepted, then the same shall have the effect to mean that even the appellants to terminate it, still the service rules need to be operated. Need to be operated in his favor by giving the difference of the gratuity which he is otherwise would have been entitled to under the service rules. That is not the understanding of the service rules, more so when there is a stipulation that on termination, the employee forfeits the gratuity. During the course of his submission, the learned counsel for the appellant had relied upon the judgment in the case of YK Singla Supra. Suffice to state that the judgment of YK Singla would not be applicable to the facts of this case, as the Supreme Court in the said case was only considering the payment of interest to the appellant, the payment of a payment of interest as stipulated under the Payment of Gratuity Act, which is more than the service fees.
No, no, here, my lord, in this case, what has happened, his gratuity was temporarily suspended under the pension regulation. There was a provision, my lord, because since he was convicted in a criminal proceedings was pending against him. Then, my lord, once he is acquitted, my lord, then it was revoked.
Payment of interest under the Payment of Gratuity Act, which was at the rate of which was more beneficial as against the interest quantified under the service regulation. Was in that background, the Supreme Court has given the benefit of interest in favor of the petitioner, Shri YK Singla. Since the issue is quite different from the one which arose for consideration in YK Singla, the said judgment is clearly distinguished. In view of our discussion about, we are of the view that he is right in dismissing the petition filed by the appellant. We also do not see any reason to interfere with the same. The appeal is dismissed.
Thirty-three, Sagar. Number 33.
Paper the petition. This case, there is a delay of 9 days. Notice is in fact already ordered and served, and no objections are filed. Customer kindly condone the delay in filing the appeal. What has been granted or not granted. Lord, on merits, Lord, my respective submission is, Lord, the appellant was appointed as a Lord clerk and data entry operator on 22/7/2011. My appointment is, Lord, approved by the Jilla Panchayat as per Annexure B, Lord, page 84. Subsequently, Lord, as per Annexure C, page 92, the approval is, Lord, cancelled without even minimum issuing notice to me. Agreed by the said order, Lord, I approached this honorable court, Lord. Service. Yes, you joined the service. I joined the service. How many? Lord, from 2011 onwards up to Lord 2018, I served. 7 years you served. Yes. Afterwards, my lord, the CEO, my lord, Jilla Panchayat straightaway cancelled without issuing notice to me on the ground that my appointment, my lord, is the salary paid to the Panchayat staff is excess of 40%. In fact, now a circular is issued which says that, my lord, I have produced along with them, my lord, additional document which says that now the government is paying salary to the staff of the Panchayat. If that is so, my lord, if an opportunity is given by the CEO, my lord, Jilla Panchayat, I could have placed this material before him and the CEO could have taken an appropriate decision, my lord, on merits.
Is excess of 40%.
40%, my lord, under 113, my lord, the staff salary will be paid by the Panchayat, my lord, income. If it exceeds, my lord, more than 40%, my lord, then we are not liable. The Panchayat is not liable to
40% of the total
income of the Panchayat. Now the state has taken decision, kindly see, the state has taken decision that now the state is paying, my lord, the salary to the Panchayat staff. Yes. That is so, my lord, minimum is I am entitled to be heard in the matter. Then the, my lord, the CEO could have taken decision in the light of the, my lord, latest circular issued by the state government. My lord, the learned single judge, in fact, the learned single judge, my lord, unfortunately, the circular was not produced before the learned single judge. The learned single judge, my lord, on page 12.
This was in existence.
It was in existence. Unfortunately, it was not brought to the notice of the learned single judge.
So, will I kindly see the order sheet? Additional documents which they have produced, it says, Annexure D is additional documents. In Kannada version,
I have translated the
3.
That is subsequent, my lord. That is, they have not relied on that circular, my lord. It's based on the facts of this case, as on the date of that, they have not produced that circular.
Gratuity file a review based on that.
Yes.
And go back to the single judge.
And my information,
Lord,
he was working on under a basis prior to appointment in 2016. And their appointment is approved, my lord, with wrong particulars. They have got the approval of the CEO. My lord, then as per the resolution of Gram Panchayat, my lord, page number 79, that resolution has not been implemented, but they have not paid the salary also. In the meanwhile, CEO has cancelled, my lord.
What is the resolution?
Resolution, my lord, to appoint him as a the Tata entry operator. Earlier to that, my lord, he was working as an honorary post. 2,000 rupees they are salarying in that Panchayat only. As per the government regulation, my lord, they have to give a publication, then call for the. Nothing was done, and they have passed a resolution. Subsequently, my lord, they have not implemented it. They prepared that.
Lord,
How did you apply for the post?
Lord, the Panchayat will appoint me. There is no regular recruitment. The Panchayat is competent to appoint, my lord, the staff.
After any notification?
No, there is no notification. Such, my lord, the Panchayat will consider our application. If there is a need, my lord, under 100 section 13 of the, my lord, the Panchayat Raj Act, my lord, the Panchayat is competent to, my lord, appoint the staff.
See, right. You will give a wide publicity.
Oh, no doubt, without, my lord,
Post.
yes. In fact, all these appointments are on contract basis. Contract basis. My respective submission is the Panchayat, my lord, the Jilla Panchayat cancelled the approval, my lord, on 23, my lord, 3/2018. In fact, on 14/6/2018 itself, my lord, as my lord, the state government has taken decision that the government will pay, my lord, salary to the Panchayat staff with effect from 2017 itself. If that is so, my lord, minimum is, my lord, the CEO could have issued a notice to me.
So, Radhamani, tell us, why don't you go back to the learner single judge? See, we say that. Now,
Yes.
let's see this. Minus that circular which you are want to rely upon.
Yes.
We can't find any fault with the learner single judge. We can't. Whatever material, he has come to the right conclusion. But this material, according to you, may make a difference in the outcome.
Certainly.
Better would be go back and tell this is the position, and the only ground on which you have rejected is that any expenditure beyond 40% of the total revenue of the Panchayat cannot be
Ground.
Go back. We will record your statement. We want to withdraw this. Go back to the learner signature by way of the review by the line of comments. Let him take a call.
Okay.
What do you say? What are you say?
Malda. Jilla Panchayat, Malda.
we can't say he's wrong. Can't say so.
My lord, one submission, since I was working as honorary basis, now this application is called for as per the regulation, my lord. Let him also appear and participate in that selection process. Most probably, my lord, since I was working on the contract basis, honorary basis.
Wait, have you advertised?
No, not yet advertised. Now, if suppose.
You tell us if you have decided to fill up the post, you have
No, that is
advertised.
panchayat, madam.
No, I can't say, I can't say that one when I can't give such promise. I can't give such promise.
There is no recruitment at all. That is why, my lord, we were appointed on contract basis. I respect this.
If this employment is there, you want to secure this employment, best is go to the single judge. With a review.
My learned friend who appears for Jalapanthi is not disputing this letter, my lord, taken by the government, decision taken by the government.
As a factual scenario, and there is already a judgment.
True.
And as an appellate court, we can't say so also, that this judgment is erroneous. Because whatever the material was there, he has come to the right conclusion. So you want, and it's a ground for review. Was the document which was in existence but was not in the knowledge.
Kindly, my lord, permit us to seek for review, lawsuit, so that.
States that after the decision rendered by the single judge, the appellant has come across what is that?
This is a letter written by this Principal Secretary of Government to the all Chief Executive Officers of the Jala Panchayat, dated 14/6/2018. Yes, Lord. All Chief Executive Officers of the state. Jala Panchayat.
Whereby it has been decided that the payment to the employees.
Yes, the payment to be made to the employees of the Panchayat by the state government.
No, my lord,
It is not there in that.
It's not like that, my lord. Only three, my lord. Three, my lord, in that.
Give us a copy, we will do it.
You will also may kindly see, but I have, along with the additional document I have produced.
English, English is there.
Kannada is there, my lord. Translation was also there.
Next, along with the additional document I have produced.
Three. ಇಂತಹ ನೌಕರರುಗಳಿಗೆ
Three.
ಕನ್ನಡದಲ್ಲಿ 3 ಇದೆ.
ಇಂಗ್ಲಿಷ್
ಕನ್ನಡದಲ್ಲಿ 3 ಇದೆ.
Along with the additional.
Next. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹಾಕಿ ಡಿ ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದೆ. ಡಿ ಅಂತ 3 ಇದೆ. 3.
ವಿಷಯ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸಿಬ್ಬಂದಿ ವರ್ಗದ ಮಾದರಿಯಲ್ಲಿ ದಿನಾಂಕ 31/10/2017 ಪ್ರಸ್ತುತ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ನೌಕರರಿಗೆ ಸರ್ಕಾರದ ನಿಧಿಯಿಂದ ವೇತನ ಪಾವತಿಸುವ ಬಗ್ಗೆ.
ಸರ್ಕಾರ ನಿಧಿಸುವ.
ಸರ್ಕಾರದ ನಿಧಿ.
3 ಅಲ್ಲಿ ಕ್ಲಾಸ್ 3. They have to pay their own sources.
Which according to him shall help the case of the appellant to seek employment. He states, we have only said it will help him to seek employment. He states that he shall withdraw the appeal and file a review petition based on the communication dated 14/6/2018. Noting the submission made by the senior counsel, the appeal is dismissed and withdrawn with liberty to approach the learned single judge in accordance with law.
Please.
Second respondent, he was served. I learned it in my petition.
You are here for.
Yes, Chief. Second.
State of Karnataka, you appear.
Yes, I have already appeared for R3.
Who appears for Taluk Executive Officer?
I already filed Wakalat.
For Taluk also.
Yes.
What about Panchayat, you appear?
R3 is concerned, R2 is concerned, I am appearing.
He appears for R4.
R4, I appear for.
Please.
Thirty-four urgent, 35.
Yes. What are your instructions?
Lords, I'm permitted to Lords file a memo seeking Lord disposal of the writ appeal. In view of the fact that Lords filed a writ petition. Lords, where I have taken up a contention insofar as issuance of the orders, Lords, imposing Lords or prescribing the conditions of service in furtherance of absorption. Where Lords, the other party has also Lords impeded. And Lords is contesting Lords the matter on the ground that Lord he is senior to me. Since all those issues Lords are being agitated there, liberty Lords to raise all the contention Lords without being influenced, because Lords the learned single judge was pleased to pass the order Lords without considering the other documents. My submission is without being Lords influenced by any of the observations made by the learned single judge in the other writ petition. Let me Lords, I may be granted liberty to raise all the grounds.
See, the earlier writ petition was on the email, you were not absorbed.
Yes,
Okay,
please.
now you are cases, you have been absorbed.
Yes,
You will agitate, so.
precisely, Lords.
Open an issue which already stood settled, that we will not do it.
Your Lords may have a look at Lords, the memo, Lords.
So you will only proceed on the premise.
Please.
Now I am absorbed.
Yes, my Lord,
And
that's all.
certain rights must flow to me as an absorbed.
That's all, my Lords. I am not.
You will work it out.
Please, your Lords may Lords consider.
You have made almost a petition.
I had to, my Lords.
Almost
I had to.
judgment.
You have included everything.
Yes, my lord. Almost judgment.
Included everything.
I had to, my Lords, because tomorrow there should not be any suppression.
Very clear.
Please.
Anything what you are saying, and it's like this. You open all my contentions
No, definitely not.
of the previous judgment. We will not, that can cause prejudice to them or anything may happen.
True, my Lords.
We will proceed on this premise, and that's what we have said yesterday. Whatever other single judge has held was on the basis of the material which was there before him.
Yes,
Okay. So that is now a past. And the
True.
that is past. Now the fresh is you are absorbed.
true.
You will agitate it. You will argue everything based on that.
Yes,
And why this big memo? You
Lord,
should have
I-
only said you want to withdraw it. There is a petition pending. I want to.
my Lords, the difficulty what I would face is, my Lords, if it is withdrawn. My Lords, probably, my Lords, to an extent that may, my Lords, be used against me.
It may not come against you. We'll tell you why.
Please.
What was the basis for him to dismiss the petition?
That, my Lords, I am not
Absorbed.
absorbed.
That's all. But that scenario has changed. You are now absorbed according to you. See, they may contest
Please,
that he has not been absorbed, rather being
Please.
appeared, they will have all the pleas.
Please.
But you will stick to your plea that I am absorbed, this is,
Yes.
this is the decision.
Please. Please.
Oh, I don't think you require this memo. You will say so, we'll take this memo.
Please.
But we will only say that the sum total of this memo is you want to withdraw this appeal. Sum total is that only?
Lords,
Is the sum total
I,
is
my
not-
Lords,
the sum total is not that.
my Lords, not, my Lords, not withdrawal, my Lords, disposal, my Lords.
It is a disposed of, he is saying dispose of the matter.
It's a judgment of the.
Then we will
Just
give.
like that.
Then we will give.
Lords, the difficulty, my lords, only with the, my lords, the choice of the words, my lord, disposal and my lords, withdrawal.
No, that's irrelevant. That's inconsequential.
Please,
We are concerned as a court, we must tell you.
please.
A thing which has been decided.
Yes,
must
my
not
lords, I
be
understand.
reopened, otherwise we will decide. That's only our concern.
Please.
Otherwise, we are ready to decide. But the thing which has been, if a thing which you have now agitated afresh, need to be decided based on all your pleas. And rightly so.
Please.
For absorption, you will take all the pleas available. You must take it. They may take any plea, but you will
Please.
stick to your stand.
My lords,
I am absorbed.
that may be clarified, my lords.
Goes without saying?
Yes, my lord, tomorrow, my lords, what happens, my lords, we are, my lords, contesting this matter, my lords, very keenly, my lords, at least from, my lords, 2020 onwards, my lords, this matter, my lords, is,
See, we want.
please,
See, we don't want,
please.
if we say all the pleas of the parties are left.
No, I'm not saying so, my lords.
Then that creates more confusion.
I do understand, my lords. But what I'm trying to say is, my lords, what I have said, my lords, in the memo is, without being, my lords, influenced by the observations made by the learned single judge in the order, let the decision be taken, my lords, by.
What do you say?
My lord, this writ appeal is filed against a decision of the, my lord, governing council, where he has given the benefit of seniority without absorption.
You're right.
And
No. He says there is a petition pending, he will go and agitate that petition. He says any decision in that petition, you will take the point that he is not absorbed, he is reverted.
That is open to him.
everything you say.
but ultimately, he will, my lord, stall my promotions to the cadre of professor, my lord, if any liberty is given.
See, he says nothing on that. He has every right of judicial review, he has gone to the single judge. That need to be decided. Okay, what his submission is, he wants to withdraw. If once he withdraws in, the judgment, earlier judgment gets final.
Please,
Becomes final.
please,
He says, any observation made therein must not come in his way when he is arguing the second petition. That's what he's saying.
please,
What do you say?
please, your lordship.
Observation must not be come in the way to argue that petition which he has filed. For the relief he is
But
seeking.
difficulties, my lord, I have been promoted and I have, my lord, given the benefit. No, my lord, say learned single judge has considered those aspects where he has not been absorbed. And he relies upon a government order, which is not the, my lord, passed after the governing council decisions. Under the regulations, my lord, governing council's proceedings should be there.
His case is, and you will see the past case was that he is not absorbed. That was his case, the earlier case.
His,
My lord, each time when he argues, when my lord, court, my lord, it will not wanted to give relief, my lord, he makes such submissions. Before the division bench also, he withdrew the, my lord, absorption itself. I accepted absorption with prospective date. He withdrew before the division bench, stating that he will, my lord, make a fresh representation.
He has filed a petition, whatever it's worth.
That is for a simple mandamus. That is a case for simple mandamus for consideration of his absorption.
He is saying is, adoption the necessary orders or conditions be specified upon absorption. He may succeed, he may not succeed. May not succeed also. You will take all the pleas, he is saying he is not been absorbed, he has been reverted, everything.
But my lord, any observation is, my lord, he will take benefit of before the single judge.
That's what we are asking.
My lord, my respectful submission, my lord, if he wants withdraw, let him withdraw, my lord, no observation may be made more.
I'm not saying that, my lord, so it should be absorbed. That matter, my lord, is pending before the single judge.
See, it will not preclude you, you will say so. This
Please.
case is, for observation must not be construed that we have opened all the pleas for the parties. That must not be construed. You may be right.
He is justified, my lords, in objecting my request.
Let me hear you.
My lords,
You make your submissions.
lords, lords, I'm not saying no to my lords, my learned friend's request. What I'm saying is, my lord, the issue, my lord, his concern is that, Lords, I may submit before the court that I have, as per the orders of this honorable court, that I will go and say that I am absolved. It is not that, Lords. I am seeking, Lords, it is my case, Lords, which is there, Lords, earlier also.
Only this.
Please.
If it is a simpliciter withdrawal,
Please.
okay? For the reason is good for both parties. That means you were dislodged or the earlier petition was dismissed on the ground that you were not absorbed. So if you are not
No.
absorbed, you are not an employee here.
That is the order in the writ petition. Against that, Lords, I am before this.
It's a single judge.
Please.
So if you withdraw it, the finding of the learned single judge that since you were not absorbed, you were not given the prayer. You were not given the prayer. But now your case is you have been absorbed.
Please.
So now consequence must flow. That's all. You will argue that. Best is simpliciter withdrawal. That's what.
Lord, sir. Only worry is not that argument may not be available to me, Lords, if I withdraw it simplicity. That, Lords, that I am already absorbed.
That obviously will not be available. No, why not it will be available? Will be available. Tell us, post this impugned order.
Please.
The learned single judge.
Please.
Post impugned order. It is your case that post impugned order you were absorbed here much earlier than.
Much earlier, after the orders of the division bench, my lords, of this honorable court. Their case is that, my lord, the orders are passed by the division bench, setting aside the absorption.
That is
As
why,
such, you are not an employee. My case is that after that, an endorsement is issued. saying
that's
that you
why
are absorbed.
Lordship, my lord, yesterday suggested for making a review petition before the single judge, my lord, producing the additional documents yesterday he produced before this court.
When that petition was dismissed, he was not having the idea, or he didn't have the information that he has been absorbed. Now he has come to know after the decision that he has been absorbed.
But my lord, what letter he is, my lord, relying upon, it is not an order of absorption.
That you will say so. You will say this is not an absorption. That is his interpretation. Your interpretation is not absorption.
That his remedy is elsewhere, my lord. Then because he has not produced it before the learned single judge. And neither the institute nor the government stated that he has been absorbed, never stated before this learned single judge.
None of us could not file the objections, my lord. At that circumstance, the order was.
Very well. We say nothing, whatever you want to take action. You tell us we want us to hear this. We will hear you. Take a call. See, he has a particular view on the whole thing. You have a particular view. He said, why should we foreclose his submission and your submissions? We will allow it, whatever is worth. We will decide if you want. Yes.
Only endeavor is that, my lord,
It's for you to take.
Please,
a call.
please.
We say nothing now.
please.
Yes. We'll pass over for 10 minutes.
Or if this matter can be taken up as a first matter in the morning itself, that's I will make such. So that, my lords, I can put it across to my, please,
Take a call. You
Please.
want- Otherwise, we are here, we say nothing. You go, what you say, you want us to hear this, we will hear it. You want to withdraw it, withdraw.
please. Please.
Tomorrow.
It's
36, BL Sanjeev.
what is this?
This matter, my lord. The respondent, my lord, was working as a driver. He was working as a driver, my lord. Even charges is unauthorizedly, my lord, he collected tickets unauthorizedly.
The usual charge. I have seen it.
My lord,
ರಿಟರ್ನ್ ಆಗಿದೆ ಇದನ್ನೇ 2 IS
My lord, punishment is, my lord, minor punishment.
One increment.
Yes. That is the. It is not that one increment has been not dismissal or.
See, tell us what has the single judge did or what has the labor court ruled?
Labor court, my lord, may I request, my lord, page 32, my lord, is the award, my lord, passed by the labor court.
Right, Vani, you have also taken a compassionate view.
Yeah.
You have just only said one increment. Now today, effect is the poor man, he will get the benefit of that one increment.
Yeah, my lord.
So, and how much is that one increment, tell us?
About 40 rupees.
That's all. He was a conductor, na?
My lord.
Conductor.
Driver.
Right.
It was a bus which was given on contract. While coming back, my lord, he has taken these passengers.
Ah.
That is the
Ah.
nine passengers, but the person who took the contract, my lord, he comes before the.
See, that's a plausible reason. He says, you take these people. He said, when the contractor, himself is saying, take these people here.
Yeah, that is the only, the court below comes to the conclusion, my lord, taking that into consideration, my lord.
This appeal has. State Road Transport Corporation. Dated 6/2/2023. This is the petition filed by the appellant here stating in paragraph 11 as a the submission of Mr. B.X. Lee, the Counsel of the Arbitration is that the court, all the who have interfered with the penalty, minor penalty imposed by the corporation of
Imposing one.
withholding one increment for a charge against the respondent, whereby he has not, whereby despite collecting the money, has not
Unauthorizedly collected. No, the issue doesn't arise. He is not a conductor. He is not a conductor, he is a driver. It was a contract bus.
has allowed certain persons to travel in the
Unauthorized.
in the bus unauthorizedly. There is no dispute that the proceedings were initiated against the respondent, resulting in the penalty that has been imposed. We find that we have already reproduced the basis for the single judge to uphold the order of the court, to uphold the order of the labor court. Since the penalty which has been set aside by the labor court and also by the learner, as upheld by the learner single judge, is of withholding of unincrement. Among the facts of this case, this court is of the view, the reviewed order in one appeals. The appeal is dismissed.
Thirty-seven. Seal number 37.
Next case is.
Still yours.
Yes.
See what?
It is on compassionate appointment, my lord. The adopted son, my lord, he wants. And after, my lord, the person dies, my lord,
Did he give, when in service books, I think to our knowledge, when he has to.
Nominate.
His service books, he gives the family details.
nomination.
Nomination.
No,
Was his name
it is
there?
not the nomination question
Wife's
because,
name was there.
no, my lord, the wife passes away earlier.
Earlier.
2011 is the death, my lord, 2000.
But which the single judge relies upon only says.
One judgment.
Adopted son is also eligible. for
No,
adoption.
according to our circulars, my lord, he is not eligible, the adopted son. That is what he said, the learned single says you reconsider. My lord, the question is, my lord, 2011 is the death, my lord. 2019, he makes an application.
Did he die?
2011, my lord.
Now tell us, so there was nothing on record this.
No, my lord. Thereafter, my lord, he goes to the civil court and says, I am an adopted son and declaration and
And based on declaration, did you release all the
we
benefits?
released all the.
How much were the benefits?
It is about 19 lakhs. 9 lakhs.
Issue notice, you issue notice.
Yes.
Got 19 lakhs.
No, I'm sorry, 9 lakhs 45,000, 54,000.
Issue notice.
Stay up. That is 7 million.
The application seeking confirmation of 68 day filing the appeal for the reinstatement of the complete appeal. The delay of 67 days is submitted. The application is disposed of. 68. The application is disposed of. In with appeal issue notice.
Stay application.
They filed any execution.
No, not it.
If he files any contempt, come back.
Well, definitely. My lord.
There is a stay application.
I have made an application.
Stay application.
Yes,
Issue notice on the petition as well as stay application.
23-9. Seal number 38.
As on date of consideration, whether the Honorable Supreme Court LIC order, it's very clear. As on date of the consideration of the application.
That's right.
What was the?
In the
Yes,
day.
that is why, my lord, stay. Otherwise, stay, I think, my lord. LIC case, Santosh case.
Then the next date of hearing, there shall be a stay of the operation of the new order. Dated meeting July 2023 after regarding with petition 3314 of 2020.
Okay.
38. There is no such thing.
But this is as against the interim order, not where the paper notification was issued for recruitment of various posts. And for the miscellaneous. Now, what has happened is, now what has happened, the term of the miscellaneous is over. Now they are by way of government notification, not they are in an extended period. And government notification says they cannot take any policy decision. Therefore, now we cannot take any policy decision till the elections are held. And in a writ petition filed by some of the members, a direction is issued to hold the election within 3 months. And also, with regard to bifurcation of this milk union into 2 different milk unions, Kolar and Chikbalapur milk unions, pending matters before the division. Not with regard to bifurcation, now an order is passed to, a special general body was convened to bifurcate the milk union into 2 different milk unions, Kolar milk union and Chikbalapur milk union. That issue is pending before the division bench. Even now, we cannot take any policy decision. Therefore,
See the order of the board, is not a policy decision. This is an order of the board.
This is no, this is interim order, my lord. Paper note, that is stayed now. That is stayed, my lord. No, therefore, my lord, we will not undertake any, my lord, now.
It is stated by whom?
By the learning single judge.
So why are we in appeal then?
Not challenging that order when, my lord, body was there. Now that, my lord, now the committee, my lord. Page 13 is the order. An interim order is passed, my lord, staying the paper notification. Therefore, my lord, I only request the matter.
No. What is the state granted which has been?
Not the paper notification was issued by the milk union for recruitment of about 132 vacant posts. That notification was stayed by the learning single judge.
Oh, that vacant, okay.
Yes, that has been stayed. Now anyway, my lord, because of the government notification, we cannot take any policy decision. And also with regard to bifurcation issue matters pending before the division. I only request, my lord, matter may be adjourned for a period of 4 weeks.
132 posts recruitment has been stayed.
Yes, stayed. We have not done. Now the committee.
It's your case also, you can't take any action.
No, the term is over now. We are in an extended period. We cannot take any policy decision now.
So then why this?
No, I only seek the matter may be adjourned for a period of 4 weeks. Not the elections are over. Not.
So then what remains in the appeal?
Not if the
Elections over, body will come, then you will decide.
Then they'll decide for the matter is pending. The issue is issue will be pending. That's it. Lords may adjourn.
Oh, at the request of Shafter or the appellant, we notify after 8.
Please. Oblige.
2110. 39, Shri Bipin Hegde.
My lordship, I appear for appellants. Seek for short accommodation, my lordship, in this matter. My senior's wife is admitted, hospitalized.
Five nine. Serial number 40, Shri Mohammed
Okay.
Sultan.
Kindly pass.
41,
Thank you, Lord.
serial number 41.
Hearing for the capital number from my learned senior basis and requesting a day's time. Also engage the senior counsel. Seek time to brief him and then make a submission. Only a day's time.
Which matter? 41.
41. My lord, the case simplicity, my lord, is this. The case simplicity, my lord. A consumer complaint came to be filed, my lord, by a home buyer. My lord, I have no problem with that. I'll only, my lord, I'll not take away the right of Arjun to oppose me, my lord, but I'll only just give. Okay, I'll only give, my lord, 1 minute background. If your lordship could my lord, very case simplicity, my lord. A consumer complaint was filed before the state commission. And my lord, at the time of filing the complaint, it was filed, my lord, against a corporate entity, company. Simply saying, my lord, the company is represented by a director. Judgment came to be passed. Even by the time of judgment, my lord, it is against the corporate entity. They wanted to, my lord, execute the judgment. My lord, at the time of executing the judgment, my lord, census turned sharp. What they would do, my lord, include 2 individuals
who are nowhere concerned with this company, neither they are the directors, as my lord respondents. And my lord, the state forum, my lord, without even looking into this. They were past directors, my lord. By the time the complaint was filed, they were no more the directors. It was the only writ jurisdiction, my lord, because what? I'll.
What is the process for keeping an execution of a state commission order? It is under the Consumer Protection Act also?
Yes, my lord, under the Consumer Protection Act.
Being sought, or you go there, they have sought the execution.
They have sought for the execution and a warrant is issued against me, my lord. Consumer for State Commission, my lord, issues a non-bailable warrant.
The consumer forum, state consumer forum, with an application.
Honestly not, my lord. I'm instructed to say honestly not.
And ask them, here, this is what you have done, and this is the position. See, without going there, going to them.
Greatly obliged, my lord. Great, with that observations.
Possibility they may agree with
Yes. With that observation, my lord, I'm greatly obliged, my lord. I'm greatly obliged. Yes.
We want to withdraw as of now this petition.
Yes.
And we are not saying that on the maintainability, we want to convince ourselves. A writ petition will be maintainable.
A writ petition is maintainable, my lord, but as your lordships rightly, my lord, put it to me, I could have exhausted that. Thereafter, my lord, I would certainly come back here, my lord. I'll just please upon your lordship to say, my lord, a writ petition is maintainable. Now I'll not trouble your lordships on this.
Will you have anything for national?
No, my lord, National Commission, because, my lord, there is a direct judgment on this, my lord. I had an occasion to argue a similar matter. The Honorable Supreme Court said, when it comes to, my lord, the execution part of it, the appellate remedies, my lord, are not available. The jurisdiction of, my lord, writ court is saved. As your lordships, my lord, rightly put it across, put it to me. Yes, my lord, I could have still gone there and made a prayer and tried to, my lord, convince the state forum that this warrant has to be withdrawn. But, my lord, what would happen is generally, my lord, it's so that, my lord, kindly, my lord, accept my apologies because I am saying this. Labor court, consumer courts, my lord, anything, my lord, said by the JDR, anything said by the JDR, my lord, is not immediately accepted because, my lord, we stand in a negative, my lord, pedestal before these courts. I will make an attempt, my lord. Kindly, my lord, save the liberty to me.
Petitioner states that we should withdraw the petition as of now. Approach the state, the Karnataka State Consumer Dispute Redressal Commission. Appropriate application.
With an appropriate application seeking recall of the warrant.
Seeking the prayers as sought in the present petition.
Yes. The liberty may kindly be reserved.
Sufficient. With liberty in accordance with law. The petition is dismissed as with law.
So grateful, so great.
42.
Thank you.
So grateful. We often, my lord, come here for two reasons, my lord. One, the proximity of the Honorable High Court. It is on the next catapult. Secondly, my lord, there is some, my lord, fantasized, my lord, hope always that.
A lawyer is in the civil court. Though a public law remedy is available, he will go to the civil court.
Exactly, my lord, exactly.
The suit is not maintained.
Yes.
Yes.
So grateful, so grateful.
Lords, the challenge.
Which number? 42. I'm on caveat. For the first and second discount. I'm only seeking it tomorrow. We'll have it tomorrow.
Absolutely no difficulties.
The request of so and so appears for caveat. Is it caveat, no? Yes.
Please, my lords.
43. Serial number 43.
Counsel for petition.
Yes, you have seen.
Please, Manoj.
Yesterday's matter.
Please, Manoj.
What do you say?
Manoj, with respect to delay, I have no submission to make. Manoj.
Then?
With respect to delay, Manoj, I have no submission to make. I can only request your lordship, Manoj, that to not, the order of acquittal which has been granted by the trial court, Manoj, the Supreme Court as well as this honorable court time and again has considered, Manoj, when the charges are similar from the criminal proceeding and in the trial court, Manoj, it has to be, that will have a bearing effect on the departmental inquiry. The charges in the trial court as well as in the departmental inquiry was same, Manoj. The allegation was the bribe that I took of 2,000 rupees. The same allegation is there in that of the disciplinary proceedings as well. On that count, I've been honorably acquitted, Manoj. On that count, there are two judgments, if I may able to. Please, Manoj.
For that, you were compulsorily retired.
I compulsory.
He was compulsorily retired.
Please,
So, but after 2009,
please, Manoj.
you have put the tribunal only in 2008.
18 minutes.
So what is the ground for
Senior
delay?
counsel is.
So we only said,
Sam
yes,
Sundaram
yes,
is
say
there.
this. You want to withdraw this? No.
Your lordship, dismiss.
The fine, the challenge in this petition is to be moderated. Please, February 2019, asked by the circular to the state of Karnataka. Then you are deciding that you the tribunal has dismissed the way by stating as under it is a considered provision that the petitioner was acquitted in a criminal case in 2009. It's much before that. In the year 2018, 2008, the petitioner was compulsorily tried. The tribunal, noting the fact that the petitioner had approached after a period of 10 years, has dismissed the OA. So we agree with the conclusions drawn by the tribunal that the delay of 10 years is fatal to stop. We also, we said that the petitioner having approached the tribunal after a period of 10 years, much after the period of limitation as contemplated under the provisions of the Administrative Tribunals Act. We do not see any reason to interfere with the the same, the appeal is dismissed.
May I request my senior's name to be shown?
Pardon?
May I request my senior's name?
She can only record your appearance. You must take the credit even though it is dismissed. Just say this, the learned counsel for the appellant vehemently argues. Okay? You have done a good job.
Great.
We have seen you in the morning also, very good.
Great.
You must avail every opportunity to argue. It is small application. There the senior say, no, I will argue important case. What is the name of the senior?
Satish Kian.
Just give the name of the senior so that his name is there. We don't want that the discussion must go to your credit. It must go to his credit. We'll give your name. Yeah,
Great.
thank you.
Great.
Just give the appearance of your senior.
Please.
44, Shibhushan. Serial number 44.
Not matter where senior architect and superintendent engineer of AIR department, not All India Radio Department, an organized service, were given the benefit of CPWD pay scale. In this plot, similarly,
I wait for the respondent.
Yes.
Yes.
Pray for some time. It may be posted tomorrow, your lordships.
What is the difficulty?
Difficulty is that I got mixed up. I took the wrong file.
Similarly, yes.
Tomorrow it may be posted.
Next Wednesday, not next Wednesday.
We will see, just see the diary, ma'am. Next week, date, next week.
Yes.
7, sir.
7th.
7th August.
7, 8, sir.
Okay.
But could be 8th, not 8th.
8 of August.
Please.
Serial number 45, Satish.
I appear for the petitioner. Lord, the matter pertaining to my lord, interstate cadre deputation. Lord, during the pendency of my lord, writ petition, Lord, the regular tenure of my lord deputation to the petitioner has expired. Lord, by virtue of interim order granted by this honorable court, I continued on deputation in the state of Karnataka, my lord, and by order dated 18/3/2023, Lord, my regular tenure got expired and I have been relieved. And my lord, I have reported to duty at Himachal Pradesh. That is, my lord, my parent cadre.
You have
Therefore,
gone back.
yes, but I have gone.
So nothing survives.
Nothing survives. But I am filing a memo. With effect.
What do you say?
I have produced.
The learned counsel for the petitioner has filed a memo of appearance, a memo for disposal, which reads as under. The learned counsel for the petitioner reiterates the prayer that in view of the fact that the petitioner has joined his parent cadre government of Himachal Pradesh, the present petition has become infructuous and be disposed of. And be disposed of as such. It is ordered accordingly.
Published.
46, Adjournment. 47. To George Anthony.
This matter, my lords, the respondent counsel in the morning, she told me that she wanted some accommodation. The pleadings are not complete. She had been given an opportunity and a date may be fixed, my lords.
Just say that re-notify, just simply say re-notify.
Earlier order.
But there is only one thing we just wanted to tell. Will this now go to the Armed Forces Tribunal?
It is the Armed Forces Tribunal. Let's prior to.
No, but the issue, the subject matter of this petition.
Please, my lords.
Must be before the Armed Forces Tribunal.
It was before the arms
Did you approach the Armed Forces
yes, my lord.
Tribunal?
I filed a writ petition. It got transferred to the Arms Tribunal.
Then?
And that got rejected. That is Annexure J at page 91.
Okay.
After that, we had been to the Supreme.
Very right. Then after that here, in view of the Supreme Court judgment.
Yes. Yeah, the cause of action got revived.
Yes. Just give some date.
So 29/8. 48, Shri Virupakshaya.
Earlier date.
We will hear you.
Objection.
48.
Forces Tribunal. Principal benches.
Unfair. Unfair.
Every decision is taken in the for the DGA, CRP, DGCIS. Yes.
Thanks, your lordship. This and the next one are corrected appeals arising out of the common order of the learned single judge. on the 16th of July 2012, the Sanskrit University, Bangalore, it is Karnataka Sanskrit University, issued a notification inviting applications from eligible candidates for posts of deputy registrar and other posts. The appellants were appointed after a selection process was held by a board of appointment, which selected them by granting age relaxation which they were eligible. And that has been found fault with by the learned single judge, who, my lord, after 12 years of our appointment, has set aside the appointment on the ground that the age relaxation could not be given. This is
Relaxation clause was there in the recruitment rules.
no, these rules themselves provided for notification itself, also provided for relaxation. But the contention of the petitioner who were unsuccessful at the selection is that we were not to be given, we were not eligible for being granted the relaxation. It's a contention that is.
For what reason they were not eligible for relaxation?
Learned single judge has accepted that and has further set aside our appointments and has finally directed that the posts which we have been holding for the last 12 years should be re-advertised and filled. This is the day. And as a consequence, we would lose our positions. And now having served for more than...
You will go back to your original position?
No, because we are working in different posts. We have no relationship with the institution.
No, was it a direct recruitment?
Pardon me?
The appointment as a deputy registrar was on direct recruitment basis?
Yes, direct recruitment.
From outside?
Yes, sir.
Oh.
Notification was issued.
You severed a relation with your previous employer?
They have no relationship. That means if we were to have a lien on the poor, our bread would not be snatched. Probably we might have gone back there. But during the last 12 years, what has happened to the respective posts which we were holding there, that is not known to us. And with your lordship's kind permission, may I read, my lord, the I seek to that very unfortunate, it may be. What I am trying to point out is the same learned single judge in an identical situation passes an order allowing on the ground of equity. Please, kindly have a look at this. With this prelude, I start my submissions to say that there must be consistency. Given situation, what the learned single judge has said is, if your lordships have no objection, kindly note the date of the present order under appeal. It is dated 15/12/2023. I would be grateful if your lordship notes it. The order which I have now produced, passed by the very learned judge, runs counter to what has been done 3 days later. And I straight away take your lordship to page number 35, internal page 35, paragraph 59. Only to shorten the submissions whether I'm making this, and then I will go to the other aspects. Paragraph. May I read, man? Page 50. Ilva. Manjunatha. I'm sorry if it.
I'm sorry.
Page 35, para 59. That before I go to other aspects of the non-failing opinion copy, I have got several copies.
ಇದು ಕೊಡಿ, ಎರಡು ಕಾಪಿ. Flagged portion may kindly be seen. Sorry if an incomplete copy had been given. And my learned friend had appeared for the petitioner in the same, in this case also, and the one which I am referring to. Para 59 thousand. Kindly refer to para 59, page 35 for a moment. Another factor to be for sustaining the appointment, this is a reason given by the learned judge just 3 days ago. 3 days later, the view changed. Another factor to be considered in this case is that the petitioners have been working as regular employees from 2012. That is, for the last 11 years, past 11 years. And at this point of time, if an order were to be made that their absorption would be illegal, it would be serious, they would be seriously prejudiced, in as much as all the petitions would be disentitled from seeking employment elsewhere by virtue of their respective ages. So age relaxation and the fact that they have served for 11 years and therefore equity would prevail, and therefore learned judge finds that they cannot be terminated. Having said so, a totally different view is taken by the same judge 3 days later in the present order. Let me refer to the order.
Finding of the learned judge in your case, saying that no relaxation could have been given.
No relaxation could have been given, is the contention of the other, was the contention of the other side.
That's right. What is the finding on that?
Yes.
Where is the finding?
Finding, my lord, is kindly go to paragraph 21. The university which appointed me through a board of appointment which conducted a regular selection has contended like this. Page 29, para 21. The argument of the university that it was entitled to consider even those candidates who were working in an aided institution cannot be accepted, since, as stated above, the exemption clause would always have to be construed strictly, and an exemption clause cannot be enlarged to the convenience of a particular individual. The statutes specifically provide for an enhanced age limit only to those who are working under the direct employment of a university or a government or a local body. And this benefit cannot be utilized by persons merely because their employer was getting grant from the government. If the post held by Prakash Pagoji, the present appellant, in the first case, in a private aided institution, that itself is the wrong finding, cannot be construed as a post that was held by him under the university or government of local body. Obviously, he would not be entitled to an enhanced age limit of 45 years, and consequently his appointment as deputy registrar cannot be sustained. The learned senior counsel put forth an argument that Gangadharappa was also working in an aided institution, and therefore he had taken the benefit of enhanced age limit, that is, the writ petitioner. While applying, he cannot therefore turn around and contend that the appointment of Pagoji was illegal. Learned counsel appearing for Gangadharappa has filed a memo. This is not that is never served on us, dated 10/10/23, and along with it, he has also produced an order dated 15/6/2021, after 2011, by which he has produced a service certificate dated 5/7/23, issued by the Kuvempu Kannada Madhyayana Samsthe, Manasa Gangotri, Mysore, which is a department of the University of Mysore. And in this, it is stated that the petitioner was appointed as a research assistant on 26/5/2011, and by orders dated so and so, and he had been working from 36 till so and so. Just digressing for a moment, your lordship's kind leave. When this was the contention taken, and we were not even aware of the nature of the appointment here, an application under the Right to Information Act was made, to the university, which has furnished a material which demonstrates not only that the petitioners, with due respect, misled this honorable court and made a wrong submission, and also suppressed material fact that they were not employees of the university. And I have obtained the copies which are not being produced. Because it is in Kannada language, it may put your lordship to a disadvantage, that I may even translate them in, file them in the due course of, because now it is the last hour of the day. I can even see that it is produced. Good. Sahib recording. Sahib recording. I can demonstrate from this document, my lord, Justice Ray would be in a position to read Kannada and subject to the order that is referred to 26.5 is produced that shows that he had been taken in a consolidated salary of 9,000 temporarily, and I'm sorry because it may be Greek and Latin for your lordship. Since it was obtained very recently, it could not be translated. Therefore, I'm seeking your lordship. I can, since my lord Justice, they would be the
3 pages.
The purport of this order is that Gangadharpa, the writ petitioner, was working as a research assistant in a temporary post under a scheme of the government, and that was for the encyclopedia, and he was on a consolidated salary of 9,000, and therefore, and he was to give an undertaking. My lord would be in a position to read Muchalake, that is, he gives an undertaking that this is a temporary appointment. Tatkalikavagi ನೇಮಿಸಿದ್ದು ಯಾವುದೇ ವೇಳೆ ಮುನ್ಸೂಚನೆ ಸೇವೆಯನ್ನು ರದ್ದು. So he was not in regular employment. And whether kindly go to page 9 of that. The extension of the appointment is contained in page 9, Miller. It is in the another order identically and similarly worded that accepting. And he again gives an undertaking to the same effect that he was a research assistant temporarily appointed for a scheme of preparation. And he was not the employee of the university, but he was also overage. And he is seeking appointment by seeking relaxation and contending that we were not entitled for relaxation. Because they cannot do standard. He was not.
Where were you working?
Yes, we were employed, mother, in different. I referred to that, mother.
But not in the university.
And learned judge says that our appointment was not under the university. What does it mean? Because university was paying us. It was a granted aid institution only, it was fully government aided, and all the Sanskrit institutions were where we were working. That were ultimately notified to be taken over by the government, and government was paying the salary. And so let me say, single judge mother makes a, what can I say, a dichotomy or a hair splitting, saying that your appointment is not under a university, and therefore you are not eligible. Therefore, now with your lordship's kind permission, I will read another page para 24 of the present judgment, page 30, ink page 30. Learned counsel, I'm sorry, I read it over, next para 20. The counsel has also produced a corrigendum in which it stated that the petitioner had been appointed as a research assistant under a special scheme. It is his for working in Vishwakosha, and for the purposes of his pay and head of account was changed. And it is also indicated that his entire salary was paid by the government. Our salary was also paid by the government. But nature of appointment, nature of the post held is important. He was not in the regular employment. This is thrust I am making. Now kindly there, next para. It is therefore clear that Gangadharappa will have to be considered as an employee of the university. That is not even the case, and not that of an aided institution. This argument, therefore, that Gangadharappa was not entitled to challenge the recruitment cannot be accepted. As a consequence, reliance placed upon the decision of the Honorable Supreme Court in R.K. Jain to the effect that only an aggrieved person in service jurisprudence can canvass the legality or correctness of an action would not be of any benefit. We contested even the locus standi that who are you, how can you challenge? And you are say, a person living in a glass house cannot throw stones at others. What's the argument, if we may say so in a later vein? So learned just says, in the case of Shilpa Shri, also respondent number 4, Shivamurthy was not eligible to apply since he was 42 years. However, it is his contention that he was working in an aided institution, therefore, he would get the benefit of his age. As already held above, an employee of an aided institution cannot equate his employment to that of an employment under the government, and therefore the appointment of Shivamurthy cannot also be sustained. As a consequence, the appointment of Phagoji as Deputy Registrar of Shivamurthy as a selection and as a section officer cannot be sustained, and the same are caused. Then what is the direction then?
What is your present status? Where are you?
No, there is an interim order of stay. There is an when the matter came up before the court for admission, the other side also appeared and contested, but notwithstanding that, the appeal has been admitted. Your lordship may kindly see the previous order sheet.
So you are continuing
We are now in employment, but this honorable court has been pleased to protect our interest, and we are now serving. The respondent university is directed to consider the applications of the petitioner along with their applications, other applicants, and appoint the most meritorious among them. University shall consider only those candidates, including the petitioners, who are eligible, keeping in mind the decision rendered in this case. So learned judge declares them as eligible, though according to me. Now, as I submitted a minute ago, it's not the trying to castigate anybody. The fact that he was working as only a research assistant for preparation of a dictionary or an encyclopedia under a scheme of the university, was never an employee of the university, having not been brought to the notice of the court. The contention raised was that they were in a regular employment till he was working even as on the date of the matter, the date the matter was heard. The learned judge proceeds on that basis and sets aside an appointment. Now that I have, before I go to any other aspect of the matter, I have one more submission. Now I started my submission with a preface that in an identical situation, the same learned judge takes a view 3 days earlier.
All right, we have heard you on that.
Yes, therefore, to take a different view would be well.
All right, okay.
This is
Let's hear
totally
them.
inconsistent with is what he said. And ineligible, sorry, one day.
Who appears for the university?
Lakshminarana, one day, one sentence. I will resume my seat, only one sentence. What I respectfully submit to your lordship is that if equity is to be considered, it must be applied to everybody. Having taken an equitable view in a given case, the previous case, that it was ineligible to quash the appointment, and that's also a case of age relaxation. No, therefore, my respectful submission to your lordship is, we would lose our bread if this is set aside. And there is no even probability that the petitions would get, accepting that they can see that we lose our job.
How many petitions were filed? Two petitions.
Two writ petitions, two appeals.
Both were similarly placed.
Correct.
Same. Let's hear you. Who appears for the university? Okay. Can you just switch on that mic?
Mysore University framed a statute signed by the governor under the University Act. Those who have worked more than 20 years. Then, my lords, the statute was not repealed. There is a letter by the governor, please terminate their services. The argument was, once a statute is framed, statute can be repealed under the provisions of the Mysore Open University Act. Therefore, statute was kept intact. Therefore, the executive order is unenforceable. That was the argument. Of course, the learned single judge drew the support stating that as after 35 years, now they are age barred. Therefore, the question of now looking into the matter afresh would not arise. But this is a case where under Rule 9(3) of the statute, where the aided persons who are working in the aided institutions are not entitled for age relaxation. They are overaged as on the date of the notice.
Tell us, what is your locus?
My locus, we have participated in the selection process.
You participated?
Yes. And
as a scheme employee,
as a research assistant appointed by the university.
But against a scheme?
All research assistants are in the scheme in the university.
But in any case, this appointment to this post of deputy registrar, was it a direct recruitment post?
It was a direct recruitment and they were aged 44 years. Age limit was 35 years. It's a overaged.
How much was your age?
We were within the age.
Within the age.
Now, my lord, kindly see the operative portion, how the direction has been issued. The respondent university is directed to consider the applications of the petitioners along with other applicants and appoint the most meritorious among them. The university shall consider only those candidates, including the petitioners, who are eligible, keeping in mind the decision rendered in this case relating to the nature of the employment. Now, now the entire case is before the university. They will have to screen afresh and find out who shall be the eligible candidate. Now, as on the date of the last date fixed in the notification, if a person is overaged, you are from aided institution and your relaxation is not within the purview of Rule 9 minutes, Statute 9. Literally, the learned single judge has interpreted the rule. They were not qualified as on the date.
No relaxation also?
No relaxation, because the Rule 3A says holding a post under the university, government or local bodies, corporation, city, municipal council are undertaking. Aided institution is not included. Is a finding by the government.
But tell us one thing. Aided institution is as good as a...
It is another authorities under Article 12.
You're right.
Yes.
So if that be so, the intent of 3A, holding a post under the university
or a government
or
local bodies is defined, corporation, city, municipal council are undertaking of the government.
So local bodies or other authorities, let's assume other authorities. So intent is, we are just only putting to it, intent is in the sense that it should be a governmental body. Yes. Intent is that. I am using the word governmental body in the larger context, maybe a state within the meaning of Article 12, but a governmental body. If that be so, where were they working?
They were working in the aided institutions, a private aided institution, which would not come within the purview of Statute 9(3)A. That's the position.
Now, only thing possibly you may have to look into, Anandi, which is that Article 12 interpreted by the Supreme Court. Yes. Where an aided institution has been held to be amenable to a writ jurisdiction.
Correct. my lord. That is, my lord ESV judgment. my lord.
Ajay has he.
19, not Ajay, sir.
Starting
There is
from
a
Ajay.
private,
Is
1985 minutes.
Anandi, I am saying, this is Anandi is the first that I remember.
Anandi.
Now there in that context, Supreme Court has said an aided institution is amenable to a writ jurisdiction for the reason an aided institution is governed by the provisions of a statutes issued by the government. It acts under the Education Act or whatever act you may call it. Or like a Mysore University Act, you may call it. So if that being the intention, your submission is aided institutions are not included or the age relaxation is not available to an aided institution. Is it your case that age relaxation is not applicable to an aided institutions?
That is the case of the university. That is the case, my lord, before the learned single judge.
Just one.
University contended otherwise. University objection statement. University contended.
See paragraph 19.
With due respect is totally a wrong finding.
The learned single judge, my lord, the paragraph 19 is only, my lord, explaining the
He
position.
says a aided institution has some governmental control.
Correct.
But that doesn't mean that government has become an employer.
Yes.
That's what he says.
So therefore, 3A, my lord, as your lordship rightly put it, it has been exemption clauses cannot be interpreted. You cannot add something like a inclusive definition and exclusive definition. Inclusive definition, we can include anything. So far as exclusive definition is concerned, court has no power. That is how, my lord, the learned.
Yeah. So tell us, when did you file the writ petition?
Year 2013, immediately after the appointment. There is no delay in appointment.
But the matter was pending before the court only.
Yes, my lord.
For 10 years and beyond.
Correct. It is an adversary system.
But
It's
you were
not
also the contenders for the post.
Yes.
Immediately I'm the next man.
Now, what do you say on this submission of yours as an employee of an aided institution? He is not entitled to the age relaxation. And where is the clause for age relaxation?
Page 26, my lords.
It has been extracted.
It is extracted.
Yeah, we have seen that.
Yes.
Even clause A says the number of years holding such post or 10 years, whichever is less, age will be relaxed. But that corresponding age relaxation is only in the context of those employees who are working there, according to him.
Under the university is what they have.
Under the university, under the government, under the municipal corporation.
Or other bodies. Or other undertakings of the government. Your lordship says, education is a state subject and that it is the paramount, it's a constitutional duty to educate the public. Therefore, since it cannot itself run institutions, large number of institutions, in fact, I may say with the statistics that education institutions which are aided and running mother on parallel lines are.
Right, that's what we are saying, aided institution, and that's the reasoning given by the learned judge. He says, an aided institution has a governmental control.
Ah.
No difficulty, that's right.
How? That is true.
But it doesn't mean that the government has become their employer.
Government, no, that cannot be.
He tries to draw a distinction.
Yes, sir.
Governmental control and an employment under the government.
Yes. A government employee would surely be governed by Article 311. Here, mother, I am not. I appreciate that distinction. I'm not. I cannot. Had it been so, mother, I would have content that I am in all respects a government servant.
That's right.
Your lordship says, lordship should kindly appreciate it. A private institution employs that who are there are private institutions which are aided and unaided in this state. What is required for an education institution being a private institution to run such an education and cater to the needs of the public at large is that it must get a recognition. So a recognized private institution which is not so aided by the government method stands on a different footing. An aided institution is for all intents and purposes virtually is that an institution run by the government, though not directly. It is not directly run, it is run by the, but entire control of the institution is, that's what I am going to point out to your lordship. This is what the learned did say in paragraph 19, page number 28.
Is there any judgment for both of you to rely upon that an aided institution, a person?
Yes, sir. I can cite a decision of that. Yes, sir. Now the time is up, Lord. If your lordship continues to the hearing of that, I will do it. I will, any day your lordship is.
In fact, an FIR has been filed against a respondent who had given a wrong date of birth in an application. Of course, that question has not been. Yes.
Give the dog a bad name.
That is how, my lads. If the university.
Give the dog a bad name and.
If the university, my lad, is permitted to examine the entire direction issued by this court, place it on record, your lordships would come.
Contention of the rising, not whether.
In fact, I conceded, my lord, when the matter came up before the vacation, I conceded, since they are working, let there be a stay. But I also made a request that the operative portion, my lords, the last direction, that let the university exercise their remedy, exercise in terms of para 29. Kindly see, my lords.
We will continue.
With your lordship's kind leave, that I place the translated copies of it.
Sir, 12.
May I take them back, because because.
Sir, date 12/8, sir.
Grateful.
12/8.
Both the cases are connected. 48 and 49 arise out of the same order.
Past over matters.
Understand.
Serial number 8. Serial number 8. Naveed Ahmad. No, sir, Martin. No, sir. Serial number 8. Yes, sir, passed those. Passed. Serial number 9. Sri Chandranath Karigar.
Yes.
Appellant. That's. Impugned order. Learned single judge order, my lords.
That we deposited the 50.
My lords, I shall deposit it, my lords. Only aspect is that, my lords, all the documents, my lords, are in Kannada. Need to get translation, my lords. Entire. The impugned order.
File section 7. Court doesn't have to file.
My apologies, my lords.
Should,
My
should
apologies.
file it.
Indeed, my lords.
Okay, file it.
Indeed, my lords.
It should be removed today. Which time we want?
2 weeks, my lords.
Weeks.
13.
Grateful, my lords.
13-8, sir.
Much appreciated.
Serial number 10.
Great.
This is 10.
10 other.
10
10 minutes.
second set ಇದೆ.
Huh?
Adal second set ಇದೆ.
Lords, mine was 10, my lords, since. My name. 9, no, my lords, since my name was called out, Chandranath Tarikas, that's the reason.
Sir, serial number 9, Nataraju.
Grateful.
15. Serial number 15.
Matter pertains to me all.
My lord, the office objection shown in the class list.
Serial number 15. Sri Radha.
Yes.
My lord, matter pertains to recovery of,
Sir.
the amount from the petitioner after retirement on the ground that there is a wrong fixation of the pay. My lord, actually, this matter is covered by the earlier order of this tribunal, my lord, which has become final. In spite of that, my lord, subsequent order becomes very well.
But office objection shown in the cost list that the statement of objection second set is not filed with regard to the respondents, my lord. I have the second set, please.
Be notified.
Very well.
Yes.
15-8. Serial number 22.
Yes.
Two concurrent judgments of the single bench of Delhi High Court. Yes. Followed by, and that is two concurrent single judge saying that arbitral tribunal is a tribunal for the purpose of writ. Then followed in approval by the division bench of Bombay High Court in 2023. Yes.
The Delhi High Court rejects the petition.
That's right. On the merits, yes, they don't find an extraordinary case for interference on the merits in any of these matters. But on the principle of interference on the jurisdiction, the second set, Lordship, the two sets. Second set, kindly see 2021 Delhi High Court at para 24. Para 24, Lordship will see at page 13. A perusal of the above mentioned decisions shows that the following principles are well settled in respect of the scope of interference of 226, 227, including orders passed under section 16. Lordship will see point 1. An arbitral tribunal is a tribunal against which a petition under 226, 227. The same is followed in 2023, which is approvingly quoted by the Division Bench of Bombay High Court in 2023. Bombay High Court Division Bench, Lordship may see, that's a third judgment. That's right. But Bombay High Court Division Bench has quoted it approvingly. And Lordship may kindly see Supreme Court. Essentially, Lordship, Supreme Court is saying the same thing. Essentially, of course, on the merits, none of these, I must fairly concede on merits, exceptional cases not made out in any of these 4 cases. But on the principle, Lordship will kindly see, I've given it Deep Industries, Lordship. It's the last judgment. Deep Industries, kindly see para 13. Lordship has Deep Industries. Deep Industries, Lordship may see para 13, page 9. Yes, Lordship will kindly see Deep, in fact, is quoted in all the subsequent judgments. Justice Nariman's judgment at para 13, Lordship may see at page 9. Lordship. I will file a proper compilation. I'll prepare a memo and.
Six eight, sir.
Right.
Serial number 40.
Hearing for petition. Kindly have it on tomorrow. Vivek sir, senior counsel is engaged in.
My lords. My lords, I appear for R1, my lords. My lords, there is an objection to the parties of the petition, my lords, where now currently the corporate debtor is into liquidation, and a liquidator would be a necessary party to this writ petition, my lords. And the petitioner may take appropriate steps to add the liquidator, because R1, the resolution professional, has not been appointed as the liquidator. There's a new liquidator appointed by the Honorable NCLT.
My lords,
That
may I just also
fact may
add?
be taken.
Resolution.
I appear for R1, my lords, as to a resolution professional, which has become functus official.
You want impeachment of which party?
My lords, may I just clarify?
Liquidator would be a liquidator.
Liquidator.
Yes, my
Yes,
lords,
my
the
lord.
writ
That
petition is
type of
infructuous as of today. This writ petition is infructuous.
As of today.
The primary argument, my lords, of the petitioner is that, my lords, they had filed a resolution plan and that was not considered. But pursuant to that, already liquidation order has passed now. So there's nothing that survives in this
It
writ
is
petition.
tomorrow. Vivek sir will come.
And I haven't filed my
One of-
objections also. I haven't filed my objections as well. Please. Please.
Tomorrow.
They are, we have it there.
Maybe
My lords may take after a week, my lords, so that we'll also file a
my lord,
reply.
the next is the permission to hand over the to for the liquidator. We are by hand actually, my lord, we will be delivering we will be providing the notice of this.
Whatever are the rules, we have not heard it. We want to hear you first before you issue. Liquidator is a liquidator now, liquidator has been appointed now.
Please. And he's not made a party, man.
There is no.
It's up to you.
But no going concern step has been taken as per the regulation 2016, my lord. Just that going concern step has to be taken. The NCLT's primary object is to revive the company.
Their objection is today. Only resolution profession is there, it has
Yes,
gone
yes.
much beyond that.
That we will be making.
Because the
liquidating
auction
as
is
a party,
also,
my lord.
the auction date is also fixed, my lord, so it's already done.
You must look into this.
Yes, yes.
Sale number 18 in the morning. I shot a date, 48 1 date. It is intermittent 286. I took 80.
Who is the counsel? But you must inform them, you don't want that.
Holiday, sir. 16/8 holiday.
But you inform the counsel.
Same होगा.
Madam Court Officer, what is the date in item number 40?
Serial number, sir?
40.
2/8, sir, Friday.
28 Friday. Thank you.
White list, sir,